கேமரா
SCDRC வந்து இந்த மாதிரி ஒரு என்ன புது கன்சியூமர் ப்ரொடெக்ஷன் ஆக்ட் வந்திருக்கு, நியூ மெம்பர்ஸ் நிறைய பேர் ஜாயின் பண்ணிருக்காங்க. ஸோ டு ஓரியன்ட் தெம் டு த நியூ கன்சியூமர் ப்ரொடெக்ஷன் ஆக்ட் ட்ரைனிங் ஒரு ஓரியன்டேஷன் ஒர்க் ஷாப் பண்ணணும் அப்படின்னு சொல்லிட்டுன்னு தேவர் ஆக்சுவலி கன்சிடரிங் திஸ், த கவர்மெண்ட் வாஸ் கன்சிடரிங் திஸ். இந்த மெயின் டைம் மினிஸ்ட்ரி ஆஃப் கன்சியூமர் அஃபேர்ஸும் அவங்களும் வந்து தே ஹேட் அ ரெக்வெஸ்ட். இந்த மாதிரி தமிழ்நாட்டுல வந்து எல்லா ஸ்டேட்ஸ்லயுமே அப்ரோச் பண்றோம். தமிழ்நாட்டுல வந்து why don't you take the lead and organize an orientation workshop on the new Consumer Protection Act for the members, benefit of the members and presidents of the consumer district consumer commissions அப்படின்னு சொல்லி அவங்களும் ரெக்வெஸ்ட் பண்ணியிருந்தாங்க. Then we coordinated with the Dr. Ambedkar Law University registrar approach பண்ணி அவர்கிட்ட வந்து can we do this together அப்படின்னு கேட்டப்போ he readily agreed. And then we went and met the SCDRC registrar meet panni. That is how the conversation moved forward. So udane registrar sonnaru we are already planning this, so we can do it together. Law university irukanga naka what more do we want, so let us plan it together appdin sollirundanga. And first next conversation was physical la pannalama appdin. In fact naanga suggest pannadhu initially maybe we should do it physical appdin solli, but then the honorable president felt ipa thirupi edo nariya fever ellam vandittu irukku, அதனால it is how safe it is அப்படிங்கற ஒரு question வருது அப்படின்றதுனால he suggested let us do it online this time. 6 days 1 week கூட அத வந்து செஷன்ஸ் ஒரு 3 hours plan பண்ணிக்கலாம். Let us try to cover all the areas. அதுக்கப்புறம் மேபி நெக்ஸ்ட் இயர்ல பண்ணும்போது வேணா we can consider doing it physical. So that is how like we are here today, and this was we have the best experts to be able to enlighten us on the various provisions of the act. அத வச்சு நாங்க எல்லாரும் அஜெண்டா with this, I would like to welcome you all once again to this orientation workshop. And let us before we move on, quickly ஒரு சின்ன request, please உங்களோட mic நீங்க mute பண்ணீங்கன்னா ஒருத்த mic ஆன்ல இருந்தா கூட it will affect எல்லாரோட எதுவுமே disturb பண்ணும். அதனால please humble request, please put your mic mute. அண்ட் எப்போ தேவைப்படுதோ அப்போ மாத்திரம் நம்ம என்னன்னாக்கா நம்ம வந்து தனியா வந்து Q&A செஷன் எதுக்கும் வைக்கல. ஏன்னா டைம் இன்னும் எக்ஸ்டெண்ட் ஆச்சுன்னா கஷ்டம், எல்லாருக்கும் 3 hours மேல உட்கார்றதுங்கிறது கஷ்டமாயிருங்கிறதுனால செப்பரேட்டா வைக்கல. பட் இந்த செஷன் முடிஞ்ச உடனே if we have time for 5 or 10 minutes we will try to have for Q&A. Maybe 1 or 2 questions we can take, and if you still have doubts, please either post on the chat box. Students irukanga university then we can ask them to note down the questions and we can actually get responses from the experts and we can write to you. That is one option. The other is you could write to the SCDRC straight away. SCDRC ku neenga mail potu இந்த செஷன்ல இந்த மாதிரியான சில queries இருக்கு அப்படினு சொல்லி நீங்க எழுதினீங்கன்னு சொன்னாக்க then we can try get responses from the experts and we can write back to you. We can clarify your questions. So this is what I wanted to tell before we went into the technical session 1. So for technical session 1, which is on evolution and overview of the Consumer Protection Act. So adukku we have an expert, Professor Suresh Mishra with us. So let me briefly introduce him and then we will hand over the session to him. So Professor Mishra is a well-known expert on consumer issues and is currently Professor Consumer Affairs and Coordinator Center for Consumer Studies at the Indian Institute of Public Administration, New Delhi. Professor Mishra holds his Masters in Political Science from Jawaharlal Nehru University, Masters in Human Resource Management from Pondicherry University, DPhil from Allahabad Central University, and Diploma in Journalism and Mass Communication. He had his advanced training in corporate governance, total quality management, and public policy management from Japan, UK, and Israel, respectively. Professor Mishra is a member of the Central Consumer Protection Council, Government of India, and member of the Copolco Committee on Consumer Policy of the Bureau of Indian Standards. He has been the project director of the National Consumer Helpline and the State Consumer Knowledge Resource Management Portal set up by the Department of Consumer Affairs, Government of India at the Indian Institute of Public Administration. He was the chairman of the committee set up by the UGC to frame modules on consumer protection to be implemented by various universities. He has been a member of several committees of the Department of Consumer Affairs. Professor Mishra has been associated with consumer studies for the last 30 years and carried out a number of research and evaluation studies sponsored by national and international agencies. His pioneering study on food wastage in social gatherings, evaluation of hallmarking scheme, and a study on the impact and effectiveness of the Consumer Protection Act 1986 during the last 25 years was received well, and a number of recommendations have been incorporated in the Consumer Protection Act 2019. He was part of the committee set up to frame the Consumer Protection Act of 2019. He has published more than 25 books on consumer issues and contributed 50 papers in journals of this repute. So we are honored to have Dr. Mishra with us. Over to you, sir. Thank you for joining us today. Professor Mishra, over to you, please. Dr. Mishra, are you able to hear me? Some technical glitch, I think. He doesn't seem to, he's not responding. Let me quickly check. Professor Mishra, are you able to hear me?
Yes, put on mute, madam.
Oh, I'm not able to see that also.
Yeah, it is there in the red icon.
Oh, okay. Then I will quickly call.
Let's see.
Is he there or is he?
No, he's
Actually, maybe he's trying to reconnect.
again he is in mute.
I'm just calling him. Hello, sir. Oh, but we could see you. Okay, but here they say that you're on mute. He says he's not able to hear anything. What could be the reason? What should he be doing? Is there anyone there to help you, sir? Yeah, please. Yeah, please. So he said in 2 minutes there is someone who is going to help him to connect. Sorry about that, sir. So this is the problem with we are able to get some good speakers because we are having the sessions online actually. இல்லைனாக்கா நம்மளுக்கு வந்து டிராவல் பண்ணி வரதுக்கு நிறைய பேர் யோசிப்பாங்களா இருக்கும். பட் ஆன்லைன் அப்படிங்கிறப்போ we are able to get experts from என்சிடிஆர்சில இருந்துலாம் பாத்தீங்கன்னாக்கா நம்மளுக்கு வந்து உடனே ப்ரொஃபசர் இவர் டாக்டர் காந்திகர்லாம் அக்ரி பண்ணாங்க. பட் சேலஞ்ச் வந்து என்னன்னா இந்த மாதிரி இந்த டெக்னிக்கல் பிரிட்ஜஸ் அண்ட் ஸோ ஹலோ ஸோ கன்சியூமர் ப்ரொடெக்ஷன் ஆக்ட் புது ஆக்ட்ல வந்து நிறைய இன்ட்ரோடியூஸ் பண்ணிருக்காங்க இல்லையா, ப்ராடக்ட் லைபிலிட்டி அண்ட் மிஸ்லீடிங் அட்வர்டைஸ்மெண்ட்ஸுக்கு ஸ்பெசிஃபிக்கா மென்ஷன் பண்ணி பெனால்டிஸ், இ காமர்ஸ் எல்லாம் நிறைய இருக்கிறதுனால தான் ஓகே let us actually like have some sessions to actually let us hear experts so that we understand the subjects better and it will help in solution discuss and actually so unfortunately first we வந்து கொஞ்சம் லேட் ஆகும்.
இது வந்து ஒரு எனக்கு தரமாக செயல்படுறாங்க. இந்த கம்பெனியில் புதுசாக வந்து அவங்க தெரிஞ்சுக்கணும், ஜட்ஜி மெம்பர் அவங்க தெரிஞ்சுக்கிட்டு சொல்கிறாங்க. ட்ரைனிங் ஏற்பாடு பண்ணியிருக்காங்க, எக்ஸ்பர்ட் நடத்துகிறாங்க. இதில் வந்து இத்தனை மணி நேரம் பிரேக்கிங் எழுதிடுவோமா, 2 கனெக்ட் ஆகும்.
இது வந்தாவே கிடைக்காது, அவங்க பேச தெரியாது. நாங்கள் உடனே சாட்டில் எழுதிடுவோம். அதே வந்து நாங்கள் இது உடனே சாட் எழுதிடுவோம். இல்லை சொல்கிறோம், நாங்கள் இப்படி எழுதுவோம்.
Thank you. வேற ஒரு சிஸ்டம்ல இருந்து கனெக்ட் பண்றாராம் சார், இன்னொரு 2 minutesல கனெக்ட் ஆயிட்டேன்னு சொன்னேன்.
Hello, ma'am. Saroja, ma'am. I am Harita. Am I audible, ma'am?
Yes.
Okay, I'm just checking that.
Yeah. Thank you.
இதுதான் பேசணும் இந்த இருக்காருல்ல இதோட சுரேஷ் அவரும் பேசணும் கனெக்ட் ஆகும் இது காட்டு பற்றி
You have joined, is it? Okay. Okay. Thank you. Join பண்ணிட்டேன்னு சொன்னாரு. Fine, fine. Thank you. யாரு? இந்த join பண்ணிட்டேன். Sir, join பண்ணிட்டேன். Join பண்ணிட்டேன். So I thought we should wait because அவர் வந்து is going to give the overview அப்படிங்கிறதுனால Consumer Protection Act ஓட overviewல இருந்து அதுக்கப்புறமா salient features of the act போனோம்னாக்க ஒரு flow இருக்கும் அப்படின்னு நினைச்சேன். அதனாலதான் I thought we should wait. Otherwise next section இப்ப மிச்ச நாள்லாம் பாத்தீங்கன்னாக்கா முன்ன பின்ன இருந்துச்சுன்னா கூட சப்ஜெக்ட்ஸ் அப்படியே கவர் பண்ணிட்டு போயிருவோம். பட் இன்னைக்கு வந்து I thought it will be good if he speaks first. ஏன்னா evolution and overview of the act அப்புறம் கொடுத்துட்டு then salient features அது வந்து அது இல்ல there'll be ஒரு கண்டினியூஷன் இருக்கும் அப்படின்னு நினைச்சேன். ஹலோ மிஸ்டர்.
Yeah, good afternoon. I've joined. Can you hear me?
Yes. Very much. Welcome, sir. Actually, I had given your introduction already. I didn't know that you were not able to hear. Are you able to hear me?
Yeah, I'm able to hear you.
Okay, yeah. So you may go ahead, sir. All are waiting for you, actually.
Okay. There is some problem with the network.
Yeah. Okay,
So,
no issues. Please
one
go
has to bear with me.
You will be speaking. I have told them that you will be speaking on evolution and overview of the Consumer Protection Act. Yeah.
PPT.
और आपको उसी करिए टैब तो जैसे कोई रनिंग कर सकती है
सर इसको ये वाला ओपन कीजिए इसको फोल्डर सर
उस पे नहीं जा रहा है
फोल्डर पे चला जाएगा ना सर ये फोल्डर को लिखिए
लिखिए तो नहीं हो रहा इसमें सब कुछ
फिर दोबारा ऑन कीजिए इसको लॉगिन
अब पीपीटी ऑन करो
Is that a problem?
खाना पड़ेगा
सर
अभी इसी को इस पे जाओ सर आप पूछो
Yeah, can you see my PPT, please?
Yes, sir. Yes, yes.
Yes, sir.
Can you see?
Yes,
Yeah,
sir.
we can.
Yes,
Yes.
we are
Okay.
able to see.
Sorry, not much I could do.
That's okay.
That's what technology is. So first of all, let me thank Ms. Saroja and the National Law University, Ambedkar National Law University for inviting me. I welcome all the presidents and members of the commissions for this session. It's always pleasure to interact with you, and online has its own, but I too as I can. The session that I have been given is Evolution and Overview of Consumer Protection Act. And so I'll be covering some of the basics in the evolution. Now, as being members of the Redressal Commission, we really need to know something more than what the Consumer Protection Act says. Then overall, what is happening in consumer protection, why you need consumer protection, what are the issues that we have in consumer protection, why the Consumer Protection Act of 1986 could not really protect the consumers as the intention was, and why do you need a new act that we have now in 1986, 2019, we have a new act. So broadly, this is what I'll be talking about: genesis, how the acts came, how the rights came into, what does the UN resolution say, and then bring you down to where we went wrong with the 1986 Act. No doubt, it was a fantastic legislation, but it outlived its utility, and therefore there was a need. So, in just this is what I'll be covering, and my presentation is there before you. Now, we very often hear this: consumer is the king. That's something which is always told. You read in books, wherever you go for a discussion, you always find this statement: the consumer is the king. But by the time I finish my presentation, you will come to know whether consumer is king or he's a poor consumer who's trapped in miseries. And therefore, he needs some kind of institutional mechanism where he can redress his issues. So therefore, consumer is king is often said, but let's see whether he is a king. Now, you'll agree that all of us are consumers, and we are consumers from cradle to grave. And that's what the old saying is. But in one of the judgments of medical negligence, the Supreme Court says that we become consumers even before birth. And so, therefore, the definition of consumer has been enlarged. Now you have, after this judgment, the introduction of the concept of beneficiary, which came into. Now, let's see what is consumer protection. First, let us understand what is consumer protection, and then let's talk about the need and what is the legislation that is there. Now, basically, consumer protection entitles to 3-4 points are there. One is value for money. Every consumer, when he goes to the market, he buys a product or service, he needs to get value for money. So that's fundamental in terms of consumer protection, that every consumer should be ensured that any product, any service that he buys, he gets a value for money. That's what the fundamental of consumer protection is. Consumers have to be aware of the contents of the items that they purchase. So all the any product or service that is being sold in the market, the consumers need to know what is the content of that product, and therefore one has to understand that there has to be the lot of information has to be there for consumers to understand what the content is. Third is essentially the safety part of the consumers who are using the products or services. So therefore, this is equally important that the safety aspect has to be taken into account. And the other more important thing that today is, the financial transactions that are taking place. And the consumers need to know about the policies, the practices that are affecting their consumers. And then above all, if there is some recourse, some wherever there is some problem, there has to, and breach is there, there has to be some recourse where the consumer could go and file a complaint. Here we have the commissions are there. Uh, so therefore, consumer protection involves that consumers are ensured value for money. They know what is the content, the product that they're using is safe, their financial transactions that are taking place, he has enough information. And the last is that if a consumer has some problems, they need to have some recourse. So this is what essentially broad of protection. Now, promoting and safeguarding the interest of consumers as regards quality, safety, standards of products and services. This is the definition. Regulating markets to prevent unfair market practices. So you need a regulator. Under the new act, you have the Central Consumer Protection Authority, which is the new regulator. Promoting fair competition in the markets. Markets have to have the level playing field. They have to be fair, and therefore, you have the competition commission is there, which is promoting competition. Competition benefits the consumer. Empowering consumer to take rational decision in the market, that's through education, awareness, seeing that the consumer has enough decisions that he can take in the market. And then setting up a redressal mechanism and providing the remedy. This is equally important. So therefore, consumer protection entails these 4-5 points. One is providing safety standards, quality and services that are there, regulating with the market so that market does not become unfair, promoting fair competition, empowering consumers through education and awareness, and last is setting up a redressal mechanism to provide remedy. Now, what are the risk areas where consumer is hurting? Now, today, if you look at the overall scenario, the environment in which consumer lives, some of the major areas that the risk that is hurting consumer is, one is unfair market practices. You have a lot of unfair market practice going on, and therefore, as a consumer, you yourself must be aware that there are large number of market practices that go on, and it's very, very difficult for consumers to understand how the market is unfair. Ignorance of consumer rights. Large number of citizens, large number of consumers are just unaware of what their consumer rights are. In fact, we did a study on which the 2019 Act came. That study has shown that there is hardly the awareness about the Consumer Protection Act of 1986. So that's the scenario in which consumer protection is being talked about. There are a lot of weak consumer movements, unlike in the West, where you have strong consumer movements. We don't have very strong consumer movement. Our advocacy groups, organizations are also, some of them are, very few of them are there. They're very active, but large number of them really do not make any mark. And therefore, you also find that the mobilization process is not functioning at all. Then you have a lot of inadequate policies. Have you ever heard of a consumer policy? You hear about agriculture policy, you hear about agriculture, irrigation, child and women development policies. So many policies are there. Policies for the weaker section, policies for the minorities. But do you hear about consumer policy? There is no consumer policy till today. New products and services are coming the market daily. You have lot of new products, lot of new services that being pushed into the market. Many of them really don't meet the quality standards of what these products are meant for, and therefore many of them are injurious to the consumers of these products and services. There is nobody to regulate these products. Ineffective redressal mechanism, that's a big issue of how, see, the consumer wants quick justice, and the Consumer Protection Act says 3 months and 5 months. As members and presidents of the commission, you yourself are well aware that it becomes very, very difficult to dispose of in 3 months. So therefore, you have large number of pendencies are there, and the consumer essentially starts losing faith in the system. Therefore, it is important to protect the consumers against 3D. D1 is defects in goods, deficiency in services, and deception in trade practices or unfair trade practice. So these are the three basic Ds against which the consumers need to be protected. Whatever goods they buy, whatever defects are there, that needs to be remedied. Deficiency in service needs to be attended, and unfair trade practice in terms of the quality, quantity, potency, and other things. So if you look at the Consumer Protection Act of 1986 or 2019, they all aim at these three things. They try to protect the consumer against defects in goods, deficiency in services, and unfair trade practice. Now, why government should intervene to protect the consumers? Government needs to intervene to protect the consumer on the grounds of economic efficiency, individual rights, distributive justice, where achieving bargaining equality between consumer and producer interest. Today, the market is such that the consumers and the producers, they are not on equal balance. So therefore, the bargaining power is always in the favor of the producer. Elevating the problems of the particularly disadvantaged, poor, elderly, so that is another. And right to development is another fundamental right. It's a universal human right where right to development is there, and therefore to protect these, the government has to intervene and bring in consumer protection. Now, if you look at the rationale for consumer protection, essentially, what does consumer protection do? It tries to address the disparity in consumer relations supplier or consumer producer supplier or the service provider in terms of bargaining power. You know, the producer has the always has the upper hand as far as bargaining power is concerned, and therefore the government has to intervene and ensure that there is a that disparity between the relationship between the supplier and consumer or producer and consumer is minimized. The producer has the knowledge, not the consumer, and the producer has the resources and not the consumer. So therefore, there's a lot of disparity in the market in terms of bargaining power, knowledge, and resources between the consumer and the supplier, and therefore there is a need for intervention. Now, you need new public policies that monitor adverse practices like food adulteration, false or misleading claims in the market and service fraud, control restrictive, abusive business practices harming consumers. Producers and sellers are responsible to ensure goods and services are reasonable, durable, and reliable. You need policies to encourage fair competition to provide consumer greatest range of choice at lowest cost, and also ensure manufacturers sellers provide adequately available reliable after sale service and spare parts. So you need a policy relating to these 4 5 important dimensions of consumer protection, where the government has to bring in policies to ensure that the consumer is safe as far as these things are concerned. Now, if we look at the genesis of consumer protection, it starts from in the modern state that say the nation state in the modern era, the genesis of consumer protection starts from 15th March of 1962, when the US President John F. Kennedy introduced the revolutionary notion of rights for consumer to the Congress. And that is where the beginning starts. But in India, we will see later that how it is much before John F. Kennedy that we had important dimensions of consumer protection. But friends, remember, as a modern day, the John F. Kennedy was the first who introduced the Bill of Consumer Rights in the U.S. Congress, where he made a definition, and he said that all of us are consumers, the largest group in the economy, but the voice is not heard, and therefore John F. Kennedy proposed that every consumer should have four rights: right to safety, right to be informed, right to choose our choice, and right to be heard. So these are the four rights that John F. Kennedy said every consumer should enjoy these four rights. And therefore, 15th March is always celebrated as the World Consumer Rights Day or International Consumer Rights Day. You'll see that 15th of March is a very important day as far as the consumer movement. It is on this day that John F. Kennedy talked about four rights to the consumers. So, friends, if you look at the origin of consumer rights in the modern era, it starts from the John F. Kennedy, the US president, who brought in these four rights. Later on, as things moved by, the Consumer International in 1982, they talked about not four rights, but eight rights. It's the largest non-governmental organization in terms of protection of consumer rights. They have done fantastic work. Many of the governments are also part of the Consumer International. So they came up with a charter of consumer rights that included eight rights. So remember, John F. Kennedy talked about four rights. Consumer International talked about eight rights. They maintained the rights of the four rights of John F. Kennedy and added four more. One was right to basic needs. They said that they should include food, clothing, shelter, healthcare, education. Now, remember that in India, right to basic need is part of right to life. The Supreme Court has enlarged right to life and brought in food, clothing, shelter, environment, sanitation as a necessary condition for right to life. Therefore, what basic needs they are talking about is very well covered under the constitutional mechanism in the country. Right to safety, that is what John F. Kennedy had also said. So the first right that the Consumer International talks about, eight rights: right to basic needs, right to safety, right to information, right to choice. Now, the ones in black, they are the ones that John F. Kennedy had already talked about, the four rights. The rights that I have written in red are the new rights, four rights that have been added by the Consumer International and making it eight rights. So you have right to be heard, right to redress, right to education, and right to healthy environment. So therefore, as far as the consumer rights genesis is concerned, it starts from 1962, John F. Kennedy, who gave four rights. Then you have Consumer International in 82. They talk about eight rights. Further, these rights were enforced by adoption of UN guidelines on consumer protection in 1985 and in 1999. In 1985, the UN resolution said that every member country should set up a mechanism to protect the consumers. That is a very major landmark in 1985. And then you have 1999 talks about sustainable consumption, basically addressing the environmental issues. Now, friends, this is what the development of consumer policy, as far as the United Nations Assembly resolution that talked about that every country should provide for the protection of consumers in terms of physical safety, promotion and protection of consumers' economic rights, standards for the safety and quality of consumer goods and services, measures enabling consumers to obtain redress, measures relating to specific area, food, water, and pharmaceuticals. So this is the UN resolution which came as a guideline on 9th April in 1985, and consumer education and information programs, they said that they should all be there. India being a part of the UN, these resolutions were binding, and therefore in 1986 uh, we came up with the Consumer Protection Act. But if you look at consumer protection in India, we have a long history of consumer protection. If you read Arthashastra, the of Chanakya, you'll find that there has been a lot of prescriptions for consumer protection, especially food adulteration, weights and measures, uh, pricing. These are the ones which have been dealt with. Then even after independence and before independence, also the British made a number of laws. So you had laws which did talk about consumer protection, Indian Penal Code, Indian Contract Act, Sale of Goods Act, Drugs and Cosmetics Act, Agriculture Produce Grading and Marketing Act. They all have existed since independence, and therefore the history or the genesis of consumer protection in India goes back to a long time. But what has happened? These acts, that which were there, none enshrined rights of consumers, nor provided swift remedy to their complaints. Now, if they did not talk about the rights of the consumers, that these are basic rights and every consumer has these rights, nor they provided for remedy to the complainants. They have to go to the uh, civil courts to file their complaint. And it's not only expensive, but it also takes time. It has other implications for which most of these acts which were there, they were more punitive in nature, and the consumer really did not get any compensation if he would go to the court. Therefore, in 1986, the Consumer Protection Act was enacted for better protection of the consumers. Now, what is interesting about this act is it follows the 1986 85 UN resolution, which talks about protection of consumer rights in every country. And after the UN resolution, we came up with the 1986 Act, which was the first fundamental act that was brought in to protect the consumers. Now, what did the Consumer Protection Act of 1986 say? It aimed at better protection of the consumers. The word better was there, which meaning that yes, there was protection to the consumers, but this act is a comprehensive act that will provide better protection to consumers. The act defined who is a consumer. So it did talk about the defining as to who is a consumer, and in a very simple word, anybody who buys a product or avails the services for a consideration is a consumer. If you get any free thing, you are not a consumer. So you have to buy a product to become a consumer, and this is what the act said. 6 consumer rights were also specified in this under the Consumer Protection Act. So John F. Kennedy gave 4 rights, Consumers International gave 8 rights, and the our Act of 1986 gave 6 consumer rights. It also talked about setting up exclusive forums for consumer disputes in all districts, state and national capital. So you had earlier you had the district forums, the state commission, the national commission. Based on principles of natural justice and summary procedure, there was no Evidence Act, no CRPC, no CPC, all those were not there. So it was very simple act that operational based on principles of natural justice. It was expected that it would deliver speedy and inexpensive disposal of complaints. The consumers themselves could take up their complaints, and there's no need to go for any legal experts or professionals or advocates, so they could really pursue their own complaints. And the time was defined that it would be within 3 months. and very small amount was to be charged as fee. So much different from what the fees that the consumers pay in the district court. So that was the intention behind the 86 Act. There were consumer protection councils at national, state, and district level. At three levels, these councils were essentially advisory in nature. They had within their jurisdiction, they could plan what activities are to be there so that the consumer are safe. It covers private, public, and cooperative sectors, so it covers all the sectors. So this is what essentially the 1986 Act, which was an act to protect the consumers, was enacted. This was the essential structure for redressal mechanism. It more or less is the same, except the pecuniary jurisdiction has increased now. Earlier, they had made under the 2019 Act, it has changed. Since you have a lot of inputs on the Act, I would not be really going into detail, but this is the structure of the redressal mechanism that was there and under the 1986 Act. The structure remains same, except the pecuniary jurisdiction has increased now. This is the Consumer Protection Council from district to state to every, you also had at the national level. I have been a member of the National Central Consumer Protection Council for almost 10 years. But it really is not very effective organization. In spite of the Act of 1986, which really talked about quality, quantity, potency, and standards, you have the markets are flooded with a lot of duplicate products like this, which I'm showing. They are all Nike becomes Hikey. This Nike is 3,000, 4,000, while Hikey is just 150 rupees. Adidas becomes Adidas. Now there is no way you can check these products coming into the market, and they are all harmful products. Consumers buy these products thinking that it is the cheap product. Many in the rural areas really don't understand the difference between Nike and Hikey, so they fall victim to such products. And the Consumer Protection Act of 1986 was not able to redress some of these issues that I'm raising. A lot of fake products in the markets. If you go below the district, you have much more of these products. They're all available. But the problem was that there was no such regulatory body that could take care of such issues. Lot of fake products in any area you see. These are matchsticks. It's very difficult to make out which is the original. But then markets, all these are all available. Now, duplicate products, even food, if you see that you find day-to-day use items like even salt, they had the duplicate products and the consumers were buying, it's being sold to them and they without any redressal. Now look at the Bisleri bottles. They're all Bisleri. The problem is when we buy a bottle, we really don't read. Label reading has to be a practice. In fact, there are two things. I insist on that. One is that if you are able to read things before you buy, you understand what you're buying, you understand how to use it, then 50% you are safe in the market. So the consumer has not only 6 rights, but the consumer also has obligations and duties. His duty is to ensure that what he's buying is correct thing, safe product, and then use it according to the instructions that are available. But most of us don't do that, and therefore market, it's all flooded with such things, and you fall trapped to it. Food adulteration is another big problem in the area, not only in the rural and urban areas, but it's existing everywhere. According to studies, the percentage of food adulteration varies from 30 to 35%. So food that you're eating, you're not sure that it is a good quality, good standard, unadulterated food that you're buying. 25 to 30% edibles sold in the market are intentionally adulterated. So you have colors, you have so many things that are there to adult. oil that you use, cooking oil that you use, there's so much of adulteration into the, especially the poorer people, those who buy in small quantity. It's very, very dicey to buy these things. It is also estimated that 90% of vanaspati sold in the market violates the specifications of FSSAI. You must have read that recently the FSSAI has said that the cow ghee sold by Patanjali does not meet the standard. Before that, they had told all the available honey in the market by whether it is Patanjali or you have Dabur, you have any other manufacturer, they do not meet the standards that are there. So we continue to use 67 pesticides that are banned in one or more countries. So as far as food adulteration also, the market is so dicey, but as consumers, we really don't know what to do. So therefore, what happened to the 1906 Act? I showed you some illustrations that in spite of the Act was inadequate in dealing with new problems faced by the consumers. There was delay in disposal of complaints, and we did a study. Our study said that the average disposal, national average, is not 3 months, but it is 3.5 years. And if you remember that the Supreme Court had also set up a committee of Honorable Justice Pasai, who also went into this, and they were very close to what we had already recommended, saying that it takes 3.5 years for disposal of complaints. There are good commissions who do it very fast, but if you take at the national average, it's a very poor situation where the disposal is really a major problem why consumers are not filing complaints today. It is no more expensive, very expensive, because most of the consumers, they just hire the services of an advocate and they forget, and therefore it costs money once you do that. Too many technical procedures. There's so much of argument that is there now. The procedures, so many acts are referred, and therefore a simple consumer, he does not understand these procedures, and therefore he gets distracted by this legislation. Now, the problem was that under the 1960 86 Act, the forums and the commissions, they started functioning like a civil court. They follow the same procedures, more or less. And these are the real problems why the Consumer Protection Act of 1986 failed. Lack of adequate infrastructure. I'm sure you understand even today, for mediation to start, you don't have the infrastructure in place. For online filing, you don't have the infrastructure at place. So this is a problem that has to be addressed if we want to strengthen the commissions. So lack of adequate infrastructure, lack of qualified manpower to man. You need people, you need qualified clerks, you need other staff to the record keeper and others to manage the commissions. And above all, lack of awareness among consumers. Most of the consumers were never aware. Now, you think one thing, the Consumer Protection Act came in 1986. While the Right to Information, RTI, came in 2005. And most of the people in this country, including people in the rural areas, they are aware that there is an RTI. Within 15 years, they became aware about the RTI. But even after 35 years, people did not know that there is a Consumer Protection Act, even though it deals with every consumer. So if there is no awareness, you don't expect the consumer to make use of the act. So therefore, these are some of the major problems, major issues that the Consumer Protection Act was looking at. Now, if we look at the factors affecting consumers in a changing economy, what has changed since 1986 Act came? When 1986 came, the world was not globalized. There was no liberalization. With 86 Act coming, that time the period was very different. It was a small economy. It was not a global economy. More of face-to-face was selling. So now this is a major change that brought in after the 1986 Act in 2009, 2000, in 1992, the liberalization and globalization process started in India. So the markets opened up, markets became different, and the problems associated with those markets came different. Unlike what they were in 1986, the markets were different then. Increase in disposable income. You can imagine how much was the income before the 86 Act, and now you see people have a lot of money, consumers have money. Consumers are demanding new goods and services. Unlike earlier, consumers would just buy what was available, and most of it was local availability for local consumptions that were there. Growth in service sector, that's a fact that has taken place. Evolving structure of the retail sector, so you have now malls which are there, and rapid technology change. We did not have mobiles when the 86 Act came. You did not have this kind of technological revolution. So you did not have e-commerce, you did not have the financial transactions that the kind that you have today. You did not have these apps, you did not. So it was a simple, small world. And now, because of the changes that have come, because of globalization, liberalization, growth in service sector, evolving the retail sector where you have mall culture, and the rapid technological change that has taken place, that has changed the world, today. Then it's also changing nature of advertising. You have a lot of, if you look at the after 86, there was no regulator for advertising. You could advertise whatever you want. And many of these advertisements became a misleading advertisement. They would lure the consumers and trap the consumers and cause immense harm to the consumer. So, friends, after 86 Act that came into, and in the period of 90s, when the economy opened up, lot of new problems also came, which were not being addressed by the Consumer Protection Act of 1986. Now, if you look at the market, what changed the market? Whole business environment has changed after the coming of the globalization, liberalization, and privatization. Markets today are much different than what they used to be. Just imagine markets before 90s. And that is the market that the Consumer Protection Act was supposed to cater to. Today, markets are diverse and they are fragmented. They are flooded with a variety of goods and services. You ask for anything that you have today, but the kind of market temptations are there. And so there is competition in the market to sell. Every producer comes up with a lot of new incentives, new ways of marketing, and so there's a tremendous competition. Due to expansion in digital technology, payment and credit risk, so now with the introduction of liberalization and opening up of the economy, you have that now technology is there. ICT is information and communication technology is being used much more. Now, because of the use of the technology, especially of payment, financial transactions that are being done, there are more risks that are associated with today. Therefore, consumers have new kind of problems in the new market that we have. Then you had the question of aggressive advertisement. As I said, there was no regulator for advertisement. So the advertisement was very aggressive. Now, if you try to understand today's consumers, so if you very often hear that Honorable Prime Minister says that, the demography is a dividend today we have. That's because we have almost 65% of the Indian population is less than 35 years. There, that's the demography that we are talking about. Young people, young consumers, they spend more money, they buy a lot of things, they use a lot of services, they travel, they go to the hotels. So it's a different kind of consumer that we are seeing today than what the consumer was before the liberalization took place. Consumer literacy has also increased. A lot it has increased today. You have many more literate consumers. Consumer finance is very easy. You can buy a product or service without actually paying anything. So you have higher purchase. They will, the manufacturer will send it to your house even without taking 0% interest there. So the market, it is now structured in such a way that people are shopping a lot, and it's easy to buy things today. It's easy to buy products today. And then there is a media that has reached every corner of the globe, which essentially makes everybody feel that this is what I want, the kind of advertisement. Cheap consumer finance, you have debit cards, credit cards, bank loans, all that is available today. So if you don't have money in your account, still you can buy a car. The spending patterns have changed over a period of 20-25 years. Today, the youngsters, they spend more, and that's how the market is growing, because there's a lot of spending that takes place. So this is the kind of consumer. So after the 1986 Act came, by 90s, the liberalization, globalization, privatization came into, and therefore you have new things. The market changed a lot. Consumer changed a lot. Consumer problems became very different, which were not there under the 1986 Act. Therefore, there was a realization of feeling that Consumer Protection Act of 1986 is not able to address the kind of problems that have come because of resulted in a globalized world. So these are the kind of problems that the Act was not able to solve. Now, if you look at the consumer buying behavior, the factors, psychological factors that motivate consumers to buy, there are a lot of studies of e-commerce that there are people who are in depression. They just go on buying whole day, they buy and they return whole day also. So that's a kind of problem that has come because of e-commerce now. You have socio-cultural factors, you have marketing factors, you have environmental factors. So now the consumer's buying behavior is also changing. Over a time, they have become more conscious of the environment in which they are there. Therefore, you also have new products and services that cater to the environmental concerns. All your electronic, especially your AC, your refrigerator, you know that star marking has come. That is only to ensure that you have a better product that is more environmental friendly. So consumers have to buy that. Now, with the new kind of problems that have come in, there is a universal emphasis again on consumer protection. There's a realization, a global realization that rapidly increasing variety of goods and services with modern technology have been made available. They're all there. Growing size and complexity of production and distribution system. You have huge corporate giants who are running the markets now, and therefore it's a very, very different kind of world that we are there. Sophistication in marketing and selling practices and advertising that has become very different. Removal of personal relationship of buyer and seller and consumers increase mobility. Most of the uh, things that you buy, online, you really don't buy from the shop who's manufacturing, but you go to a third party and you buy it from a platform. It's just like a hut. You buy it from platform. for which the seller is not claims that he is not responsible for anything that is there. So again, because of the emphasis, more and more emphasis on consumer protection in a new globalized world, the UN issued new guidelines. Remember, the first guidelines were issued in 1985, asking countries to make procedures and for welfare of the consumers. And then keeping in view the growth in exploitation of the consumers in a new way through technology and other things, UN guidelines on consumer protection came in 2016, where the emphasis was on e-commerce, data security and privacy, protection of consumers in financial services, and sustainable consumption. These were the four major areas where the UN guidelines said that in terms of e-commerce, you have to have some protection for the consumers. They cannot just be left to the markets. Data security and privacy is a big issue. The consumer's data should not be misused. Consumers' privacy has to be ensured. Financial services are taking consumers for a ride. Therefore, use of technology in financial services has to be ensured that there's a protection of financial frauds, and sustainable consumption is something that for better environment of the world, that we leave back something better for our next generation. So these were, you see the shift that has taken place from the UN guidelines on consumer protection in 1985 and UN guidelines on consumer protection in 2016. Totally a different kind of protection has come. 86 talked about basics, that consumer has to be provided, consumer has to be given education, consumer has to be kept safe, all these things. But now in the 2016, in a new world, in a new kind of environment where consumers are being cheated, exploited, we need to focus on some of these basic issues. Therefore, there was a realization that you need a new kind of act. And the Consumer Protection Act was 86 was not able to provide a comprehensive protection to the consumers due to a variety of reasons that I have already talked about, mainly being globalization and ICT, which has changed the business environment, and therefore consumers were more vulnerable to various new challenges. E-commerce has emerged as a major market platform, and the growth of e-commerce has doubled after the COVID. More people are now buying through e-commerce because it's convenient, it's easy. A lot of things are also cheap on e-commerce platforms, but then along with it, there are a number of problems that are associated with it. It was also felt that a lack of a regulator was felt, as suo motu action could not be taken. Neither the district forums, nor the state commission, nor the national commission had the power for suo motu action. So they could take action only when somebody files a complaint. But even though there was so much of exploitation in the market, they could not take any action. So there was a feeling that a regulator has to be there. And in the new act, you have the new regulator is there, CCPA. Like you have regulator in many of the sectors. In the airline, you have a regulator. You have a regulator in the higher education, which is UGC. You have regulator in food safety, FSSI. You have a regulator in telecom, that's TRI. You have a regulator in insurance sector. But there was no regulator to protect the consumers in all sectors. So therefore, there is the need for a new act has to be there. The consumer has also changed in these 3 decades. A different kind of consumer, more educated, more confident, having more money, and having the desire to have a good quality of life, so he'll buy more products and services. So therefore, uh, the the need to promote quality standards and innovation in the market. Therefore, there was a realization that you need a new act. So therefore, we have the Consumer Protection Act of 2019 because the 1986 Act, Consumer Protection Act, that was relevant, and it did protect consumer to a very limited extent, but within a decade, because of global changes that took place, the act was really not able to do much. And therefore, you have the new Consumer Protection Act 2019 and the presidential as it came in August 2019, and the new act came in force on partially July 20, and the rest of the provisions on you have in July 24. And for operationalize these acts, the government has also notified rules on e-commerce. Mediation is there, appointment of president, members of state and district commissions, general rules, NCDRC regulations, a lot of other paraphernalia. Along with that, filing of the the electronic filing, all those things have been they are provided in the act. Uh, it really it tries to cover up the lacuna that was there in 1986 Act, because the act, that became very technical and cumbersome for a consumer really. And the highlights are the act aims to widen the ambit of consumer protection, broader definition of consumer, which includes both offline and online transactions. It equips the machinery to meet new challenges, efficiency in grievance redressal. That means you can file online, you have video conferencing. Everything, most of it is you can do online itself. You don't have to. And inclusion of e-commerce, because of the growth of e-commerce, global e-commerce growth is there. You can buy or sell products electronically. So that's a big market that has emerged, which was not there in 86. And therefore, this act tries to cover up this. Flexibility in filing the complaint. The consumer can file from wherever he resides or works. Increase in pecuniary jurisdiction. Initially, the jurisdiction was higher. Now it has been brought down because the Supreme Court was taking cognizance of many of these issues. And we were asked, IAP was asked to prepare the report of the impact of the 2019 Act, and especially increase in pecuniary jurisdiction, where we said that it has to be lowered. Otherwise, the study brought out that the assessment was that if National Commission has pecuniary jurisdiction is above 10 crores, then the study showed that within 5-6 years, once the backlog is over, National Commission may not have more than a few dozen complaints. So therefore, the problem was there because now there's only single appeal is there. So many of the complaints earlier, from the district forum or now district commission, the complaints would end up in the Supreme Court also. Especially if you look at the telecom complaints, they did end up there. But now that is not there. Therefore, with such high pecuniary jurisdiction, it will be very difficult. And with 1 crore, all the complaints will be flooded in the district commission, which will really overburden the district commission. So therefore, we recommended that the pecuniary jurisdiction should be brought down. We submitted the report was submitted by the Department of Consumer Affairs to the Supreme Court, and Supreme Court accepted that finding that 50 lakh should be fixed for the the district commission, and subsequently more than 2.5 crores should be for the commission. So therefore, the pecuniary jurisdiction has now been lowered than what it was recommended. You have the Central Consumer Protection Authority, that's the regulator, a very important body that you must be well aware, taking a lot of action against misleading advertisements, unfair trade practice. It has become very active, vibrant institution for the protection of consumer rights. Mediation as a means to resolve consumer disputes. You need to have a mediation center selection of mediators, training of mediators, and then the process. Now it's question of how this thing is really taken up. You need a lot of infrastructure, you need manpower, so that you can resolve some of these disputes. Product liability is something very good that has come in. Provision for strict liability of manufacturer. So these things I'm just mentioning because they as a passing reference, but in greater detail, it will be covered in the subsequent sessions that you have. So I stop here. That's the my. If you have any questions, you are welcome.
Thank you, Professor Mishra, for the detailed overview of the Consumer Protection Act. So I think we have 10 minutes. So if there are any questions, I think we can take up. So if there are any questions, if there are any questions, please raise your hand. Participants, all the honorable presidents and members, if you have any questions, please raise your hand and we can actually direct the question to you. If there are no questions, we can actually move on. Thank you, Professor Mishra.
Okay, thank you so much. Thank you.
Thank you. Yeah. So,
Can you hear me?
yes.
So can you explain the difference between old act and new act?
Sorry, your question is not clear. Can you repeat, please?
Can you explain the difference between old act and new act?
Can you explain the difference, is it?
No.
Between old act and new act.
Sir, they want to know the difference between the old act and the new act.
Okay, the broad difference is that the pecuniary jurisdiction is changed. You have mediation in the new act, you did not have in the old act. You have consumer protection authority regulator, which was not there in the earlier act. You have e-commerce, which protection in e-commerce, which was not there in earlier act. Online filing is there in this act, which was not there in earlier act. And then now a lot of administrative powers have also come. The National Commission has the power to supervise up to the district commission. And the central government has been vested with the power to, take action against the district commission also for non-performance. So these are some of the broader issues that are there. But especially the filing of complaint. Now the consumer can file complaint from the place of residence or where he is working. Earlier this was not there. So there are many such. I'm sure the speaker who will cover the act, he will explain to you in detail about these things.
Thank you, sir. Thank you.
Madam, I want one.
Hand raised, Mr. Satish Kumar. Sir, please go.
Want to difference between the section 71 and 72 in Consumer New Act.
Sir, we can go to the next session where we will be talking about the salient features of the act. I think it will be covered in detail by Dr. That's going to be our next speaker. So I think she will be able to go right on this question actually. Professor Mishra, if you would like to respond, you may, but I thought it would be good if this is possible.
No, I would leave it to the next speaker because that's, it needs a different kind of explanation which will take So next speaker would be a better person because you have to cover other sections along with this section then.
Yes.
Yes, sir. Thank you. Thank you.
Thank you.
Thank you.
Yeah, thanks. Okay. Thank you, Professor.
Thank you so much. Thank you. Thank you. Thanks.
Now,
can you hear me?
Sir,
yeah, I can hear you. Yes, I can hear you. Yes,
hello,
sir.
sir. How are you? This is Shankar from Tamil Nadu.
Yes, sir.
How are you?
Fine, sir. I'm fine.
Nice to see you. See, my question is,
Yeah.
my question is,
Yes,
see,
sir. Right.
recently the Delhi courts instructed about the infrastructure facilities in the consumer commissions.
Yes, sir.
Heard about all these things. But in all throughout India, the basic infrastructures in commissions is very much needed. So I would request the IEPA to take, based on your, already you have submitted a survey to Government of India, and based on the survey, the basic infrastructures be strengthened in all consumer commissions. So I request IEPA to take up this.
Sir, that report, we submitted the report to the government. They submitted it to the Supreme Court. You must have also read in the newspaper. We covered lot of issues, infrastructure, finance, manpower, and Supreme Court has issued some directions. Now it's very difficult for central government to take action against state government if it's for state governments now. Even if you look at the salary or honorarium of the members and presidents, there was so much of fight to get it increased. It's not an easy job. So now the act is there, so the state governments have to act on it and ensure. I think the central government has issued a lot of money for mediation cell and others, but space has to be given by the state government. And so I'm sure that in times to come, I agree with you that infrastructure, manpower, resources, powers, all these are very important, vital in your IT infrastructure also. So our report was very comprehensive, which the Supreme Court has accepted, and they have also issued directions. Now it's for the state governments to really take it up. You have to pressurize them to do it. Thank you, sir.
I see a couple of other hands raised. Mr. Meenakshi Sundaram, Vellore, DCDRC. Is there any question that you would like to ask, sir? Vellore, Tiruvarur.
Yeah, please go ahead. I'm here. I'll try to answer whatever I can.
Yeah, and we have 5 minutes also. So if there are any questions, Tiruvarur also I see hands raised. So, okay. Yes, sir. I think it's by mistake. So yeah, thank you. Thank you very much, sir.
Okay, thank you so much for your invitation. Thank you.
Thank you. Thank you very much. So now we move on to technical session 2. So where we will be talking about, in fact, for one of those questions, I think we'll have answers in this session. So we have, sir, if you could actually, your presentation, if you could actually stop sharing your presentation. Thank you, sir. Thank you very much. So we have Dr. Harita. Harita Devi, who is a faculty member at the Tamil Nadu Dr. Ambedkar Law University. She teaches business law and holds the charge of Director, Research Publications and Academic Affairs and the Department of Environmental Law. She graduated from Government Law College, Trichy, and did her post-graduation from School of Legal Studies, Cochin University of Science and Technology, and doctorate on reproductive rights of women, emerging legal trends in India from the Tamil Nadu Dr. Ambedkar Law University, Chennai. She has presented around 35 papers in national and international conferences, has published articles in 15 journals, has written 10 chapters in books, and authored a book. She has been the editor of 5 volumes of books and 3 journals, including the Handbook on Consumer Protection Act 2019, published by the Tamil Nadu Dr. Ambedkar Law University in association with the Ministry of Consumer Affairs, New Delhi. She's also one of the editors of Nugarvor Padugappukkaana Vazhigaatti, published by the university. So we are happy to have her here. We'll be actually talking about the salient features of the Consumer Protection Act 2019. So we have 2 sessions today and tomorrow. The first session will be like on the same topic. She'll be continuing on this. Over to you, ma'am. Thank you for being here. Thank you.
Thank you, ma'am. Thank you all for inviting me once again. In fact, our university is also in association with our university. This program has been conducted. In that, I am very happy. Am I audible? Hope
Yes.
I'm audible to all of
Yes.
you. Yes. Yeah.
Yes.
So it's a very, I feel it as a privilege to stand before this crowd because in fact, we all only teach consumer protection, but here we have people who are being practicing it or who are the ones who execute it. So at the outset, I'm honored to stand before you all. நடுவுல தமிழ்ல பேசலாமா அப்பலாம் இல்லையா
சொல்ல வந்தேன் bilingual-ஆ இருக்க ரொம்ப comfortable
இருக்கலாம் இல்ல I just wanted to ask I just asked if you permit we'll continue in both ஏன்னா நுகர்வோர் பாதுகாப்பு சட்டத்தை நடைமுறைப்படுத்துறவங்க முன்னாடி நான் நின்றுட்டு இருக்கேன்றது எனக்கு தெரியும் ஸோ எவ்ரிடே யூ கோ ஃபார் இட் அண்ட் இட்ஸ் வெரி நைஸ் டு see that I feel that 1986 Consumer Protection onwards itself, it's a very remarkable legislation because it's one of the legislation which gave the consumer some rights, I would say. Of course, today, after 2019 Act came, we all say that that Act had so many confusions or so many, it was had so many drawbacks. Ellam correct. But 1986 1986 அந்த சட்டம் வந்தபோது நிஜமாகவே எனக்கு என்ன தோணுதுன்னா அதாவது அந்த சட்டம் வந்ததுல இருந்து தான் இந்த நுகர்வோர் அப்படின்ற ஒருத்தர் இருக்காங்கன்னே நமக்கெல்லாம் தெரிய வந்ததோ இல்லை எல்லாருக்குமே தெரிய வந்ததோ இப்போ ஒரு கொஞ்ச நேரத்துக்கு நீங்க எல்லாரும் அதை எக்ஸிக்யூட் பண்ற ஆஃபீஸர்ஸ்னோ இல்லை நான் அதை டீச் பண்ற பர்சனோ மறந்துட்டு யோசிச்சோன்னா நம்ம அத்தனை பேருமே வந்து நுகர்வோர்கள் தான். We all are consumers from morning till evening. Everything we use from morning, if we take our brush, there starts our consumer. At night when we go to sleep, whatever we use, yes, again we are consumers. ஸோ அந்த வகையில் நுகர்வோர் பாதுகாப்பு சட்டம் அப்படின்றது என்னை பொறுத்த வரைக்கும் என்னோட தாழ்மையான ஒரு இதுன்னு நான் நினைக்கிறேன். அதாவது அது வந்து ஒரு வெறுமனே யாரோ ஒருத்தர் கற்றுட்டு யாரோ ஒருத்தர் அதை இம்ப்ளிமெண்ட் பண்ணி இல்லை, எல்லா நுகர்வோருக்கும் இது போய் சேரணும்னு நிஜமாவே நான் நினைக்கிறேன். ஸோ அந்த வகையில் நீங்கள் வந்து அதை இம்ப்ளிமெண்ட் பண்ணுறவங்களும் சரி, நாங்களும் சரி, ஸ்டூடெண்ட்ஸும் சரி, நிறைய பேர் இதை கொண்டு போய் சேர்க்க முடியும். சேர்த்தால் தான் வந்து நிஜமாவே கன்சியூமர் ப்ரொடெக்ஷன் அப்படின்றதுக்கு ஒரு த ரியல் மீனிங் வில் கம். அதுக்கு நான் ஆரம்பிக்கிறதுக்கு முன்னாடி நம்ம எல்லாருமே லா படிக்கும்போது ஒரு கேஸ் ஸ்டார்ட்ஸில் படிச்சிருப்போம். நம்ம எல்லாருக்குமே ஞாபகம் இருக்கும்னு நினைக்கிறேன். டொனாக் வர்சஸ் ஸ்டீவன்சன். சப்போஸ் மறந்து போச்சுன்னா நான் அதோட ஃபேக்ட்ஸ் மட்டும் சொல்கிறேன். ஜஸ்ட் நம்ம எல்லாரும் பேசுகிற ஒரு இன்னைக்கு வரைக்கும் நம்ம அதை பார்க்குற ஒரு விஷயம்தான். 2 பேர் போய் ஒரு ஜூஸ் பாட்டில் வாங்குறாங்க. they are buying a juice. ஸோ இன்சைட் தட் there was some insect. அவ்வளோதான் அந்த கேஸ். சாதாரண ஒரு கன்சியூமர் இஷ்யூ, டொனாக் வர்சஸ் ஸ்டீவன்சன். அந்த கேஸ் அவ்வளோ பெரிய கேஸ். ஏன் அவ்வளோ பெரிய இஃபெக்டிவ் கேஸ் அப்படின்னு சொல்லலாம். பெரிய கேஸ்ன்னு சொல்கிறத விட இஃபெக்டிவ் கேஸ். ஏன்னா அது ஒரு 18th century கேஸ். நான் ஏன் அதை இஃபெக்டிவ் கேஸ்ன்னு பார்க்குறேன்னா அப்போவே வந்து இந்த மாதிரி அந்த பாட்டிலுக்குள்ள இந்த இன்செக்ட் இருந்தது அப்படின்னு சொல்லி அவங்க கேஸ் போட்டு காம்பன்சேஷன் வாங்கினாங்க, ரைட்? பட் நம்ம இன்னைக்கு வரைக்கும் இந்தியாவில் எஸ்பெஷலி தமிழ்நாட்டில் இருக்கிற ஒரு நுகர்வோர் இந்த மாதிரி ஒரு இன்சிடென்ட் நடந்தா எத்தனை நுகர்வோர் கேஸ் போடுவாங்கன்னே நமக்கு இன்னும் தெரியாது. We are in 2022, correct? That case happened somewhere around 1856. But I think it is 1856. If I am wrong, kindly correct me. But இன்னைக்கு 2022ல கூட நம்ம எல்லாரும் ஆன்லைன் கன்சியூமர்ஸ், நிறைய விஷயங்கள் வாங்குறோம் ஆன்லைன்ல, எல்லாம் ஓகே. பட் நம்ம இப்போ கூட ஒரு கேஸ் அந்த மாதிரி ஒரு விஷயத்துக்கு போடுவோமா? ஃபார் எக்ஸாம்பிள், நம்ம ஒரு 10 ரூபாய்க்கு பேனா வாங்குறோம்னா அது 5 ரூபாய்க்கு தான் எழுதுது இப்போ வரைக்கும். பாதி எழுதுது, பாதி எழுதலை. நம்ம எல்லாரும் இதை எக்ஸ்பீரியன்ஸ் பண்ணியிருப்போம்னு நினைக்கிறேன். ஆனால் நம்ம யாராவது இந்த பாதி பேனா ஏன் எழுதலை, எனக்கு அந்த 5 ரூபாவை திருப்பி கொடுன்னு காம்பன்சேஷனுக்கு போவோமா? இது ஒரு பெரிய கேள்விக்குறி. பரவாயில்ல 5 ரூபா தானே கமான் விட்டுட்டு அப்படியே போயிடுவோம். ஸோ தட் இஸ் வாட் வி ஆர் டூயிங் ஆஸ் கன்சியூமர்ஸ். ஸோ ஆஸ் கன்சியூமர்ஸ், this Consumer Protection Act has to go a long way because it is a very, very bold step taken by our government or legislators to legislate, to bring out a new legislation completely repealing the 1986 Act. So let me go to the salient features of the Act. I think I must share my, yeah. Is it seen? Terida?
Yeah.
Screen? Yeah.
Yes. Yeah. Thank you.
Yeah. If I am not audible or if my screen is not visible or moving or anything, please interrupt me. Feel free to interrupt, no problem. We can discuss. So, salient features of the Consumer Protection Act. Actually, இதுக்கு முன்னாடி பேசின ப்ரொஃபஸர் சரே வந்து நீட் ஃபார் த ப்ரொடெக்ஷன் ஆஃப் திஸ் ஆக்ட் ஆக்சுவலி சார் சொன்னாங்க. பட் ஒரு இன்ட்ரோன்னு ஒரு ஜஸ்ட் ஒரு பாயிண்ட்ல ஏன் இந்த ஆக்ட் வந்திருக்கு அப்படின்னு ஜஸ்ட் பிரீஃப், வெரி பிரீஃப். ஐ ஒன்ட் கோ இன் டு த டீட்டெயில்ஸ். The thing is, the first reason why Consumer Protection Act came is because of digitalization. The first reason and the foremost reason why we needed a new Consumer Protection Act is because of digitalization. So, இன்றைய காலகட்டத்தில் எல்லா இடத்துலையும் நம்ம வந்து இந்த டிஜிட்டலைசேஷனை பார்க்குறோம். தட் இஸ் மின்னணு வழியாக எல்லாமே நடந்துட்டு இருக்கு, ரைட்? அது பொருள் வாங்குறதா இருந்தாலும் சரி, காசு கொடுக்கறதா இருந்தாலும் சரி, all banking transactions or anywhere you go, we are all on digitalization, correct? So because of the digitalization, there was a need to bring about a new legislation. E-commerce also. இன்னைக்கு ஒரு வீட்டில் இருக்கிற ஒருத்தர், வேலைக்கெல்லாம் போகல, சாதாரண ஒரு ஆள் அப்படின்னு கூட நினைச்சுக்கோங்க, காய்கறி வாங்குறது கூட e-commerce தான் இப்போ. So nobody is very happy to go to the shops itself. Instead of that, everything you get in online shopping. So that is where e-commerce is electronic commerce. So everything is happening through digital transactions as well as electronic transactions. So that's the place or that's the need for bringing about a new legislation. So the rudimentary aim of this act, the basic, very basic of aim of this act is to safeguard the rights of the consumers by establishing authorities for timely and effective administration and settlement of consumer disputes. So, அதை ஜஸ்ட் பார்க்கும்போது எஸ்டாப்ளிஷிங் அத்தாரிட்டிஸ், உடனே நிஜமாவே நீங்க எல்லாருமே கேட்க வேண்டிய ஒரு கேள்வி, அப்ப இதுக்கு முன்னாடி அத்தாரிட்டிஸே இல்லையா, நாங்கெல்லாம் வந்து கமிஷன்ல வேலை பார்க்கலையா அல்லது கமிஷன் இல்லையான்னு? இருந்தது. From 1986 itself, the 3-tier consumer protection, everything, authority, state commission, district commission, national commission, everything was there. But the basic aim of bringing a new legislation in 1986 was to avoid the late or the time restriction. That is, ஒரு ஆர்டினரி கோர்ட்ல போய் ஒரு கேஸ் போட்டோம்னா, சிவில் கோர்ட்ல கேஸ் போட்டோம்னா, காம்பன்சேஷனுக்கு கேட்டு போட்டோம்னா, அது எடுக்கிற அந்த காலை அளவை ரெடியூஸ் பண்றதுக்கு தான் கன்சியூமர் இஷ்யூஸை மட்டும் தனியா ஒரு ஃபோரம் கொண்டு வருவோம்னு அப்ப கொண்டு வந்தாங்க 1986, ரைட்? பட் அன்ஃபார்ச்சுனேட்லி we have to agree, we all have to agree that சிவில் கோர்ட்ல பெண்டிங்கா இருக்க வேண்டிய கேசஸ் கன்சியூமர் கோர்ட்ல பெண்டிங்கா இருக்கு அப்படின்ற ஒரு நிலைமைக்கு தள்ளப்பட்டோம். ஒரு 2018-19 அந்த இடத்துல ஒரு சர்வே மாதிரி நடக்கிறப்ப the government was or it was identified that there are so many cases pending before consumer forums also. So the present act, புதுசா வந்த இந்த 2019 legislation is for establishing authorities for timely and effective administration and settlement of consumer disputes. So settlement, timely and effective, that is the most important point, which as officers, presidents and members of the consumer forum have to have that in mind, because it is for that purpose that this legislation has come. Settlement of consumer disputes சொன்னா கூட அதுவும் ஏற்கனவே இருக்கு. இப்ப இருக்கே என்ன கன்சியூமர் டிஸ்பியூட்ஸ், இப்ப என்ன மறுபடியும் என்ன செட்டில் பண்ண போறோம் அப்படின்னா effective settlement of consumer disputes அப்படின்னு வரும்போது இன்னைக்கு ஆன்லைன் கன்சியூமர்ஸ் வளர்ந்துட்டே வராங்க. So there are more number of people who are purchasing things through online or e-commerce transactions is on the rise. அப்ப நான் ஒரு பொருளை கடைக்கு போறதுக்கே சோம்பேறித்தனப்பட்டு தான் நான் வந்து ஆன்லைன்ல வாங்குறேன், என்னோட ஈஸி கோயிங். அப்ப ஆன்லைன்ல நான் வாங்கின பொருளுக்கு டிஸ்பியூட்னு வரும்போது மட்டும் மறுபடியும் கோர்ட்ல போய் அவ்வளோ டைம் செலவழிக்க எனக்கு இல்லை. That is the point, right? So effective dispute, settlement of consumer disputes, how to bring about new ways to settle the disputes, that is the aim of this new legislation. That is the reason why a new legislation was needed. Need for new Consumer Protection Act is this: digitalization, e-commerce, and we need timely and effective administration and settlement of consumer disputes, right? And of course, this all everybody knows. Background of the Consumer Protection Act 2019. It was actually introduced in the Lok Sabha by Mr. Ram Vilas Paswan, the Minister of Consumer Affairs, on July 8, 2019. And it was passed by the Lok Sabha on July 30, Rajya Sabha on August 6, 2019. It was notified in the official gazette on August 2019, and it came into force from the 2020 onwards. I think dates இதெல்லாம் வந்து எப்போ Consumer Protection Act வந்ததுன்றது. Actually, the Consumer Protection Act 1986 is repealed. So it's not amended, it's actually repealed. Now we are only implementing 2019 Act. And after the 3 decades, this has been replaced. That is from 86 to 19, it was survived only. So this act has been enacted with a view to widen the scope of consumer rights. So as the previous professor has already told, United Nations guidelines lerunde consumer rights irukku. So everything is already there. But now we are widening the scope of consumer rights to cover the field of e-commerce, direct selling, tele-shopping, and other multi-levels of marketing in the age of digitalization. So we all know what's multi-levels of marketing. Today, marketing has expanded its arena. Just click a button, things will come to your home. That way we are living. So in that era, we need to enlarge or widen the scope of the consumer rights. And this act aims at revamping the settlement and administration process by imposing stricter penalties, comprehensive definitions, and more protection to consumers. இதுதான் வந்து அதோட salient feature. சொல்லப்போனா ஒரே லைன்ல salient feature சொல்லணும்னா, the settlement and administration process has been revamped completely. Of course, on the forum, 3-tier system, that and all is there, but still little more revamped. Stricter liabilities or penalties are imposed, and there are some new definitions introduced in the act, so that there is some comprehensive definitions in the act, and this gives more protection to the consumers also. And now we move on to the salient features. I start with the preamble of the act. Everybody knows what is the preamble. By now, while implementing, you would have seen 101 times this preamble. But still, yes, only 3 points. To establish authorities for timely and effective administration, protection of the interest of consumers, settlement of consumer disputes. So it's very plain, very easy to understand, but it has a lot of meaning inbuilt in it. When we say protection of the interest of consumers, we need to understand there are variety of consumers. It's not only people who go and buy things in the shop. Even in the shop, we all know there are variety of consumers, like there are people who will buy only branded items. நான் வந்து போட்டா I will go only to என்ன சொல்றது, I'll go to only Bata showroom, I'll go only to Lakme beauty parlor. So anything branded, right? And if you take shirt or anything, only branded items use பண்ற கன்சியூமர்ஸும் நமக்கு இருக்காங்க. இல்லை டி நகர், சென்னையில் இருக்கவங்களுக்கு தெரியும், டி நகர் ஒரு ஷாப்பிங் ஏரியா. பாண்டி பஜார் போனீங்கன்னா நம்ம பெரிய ஷோரூமில் கிடைக்கிற அதே ஷர்ட் மாதிரியே இருக்கும். ஆனால் அங்கே 5000 ரூபாய் இருக்குன்னா இங்கே 500 ரூபாய் தான் இருக்கும். ஸோ டிஃப்ரென்ஸ் வில் பி தேர். ஆன் த பிளாட்ஃபார்ம் ஆல்சோ வி வில் கெட் திங்ஸ். They are also consumers only. So whatever, any type of consumer it can be, or any level of consumer you can be, anything you buy for 50 rupees, 5 rupees, 1 rupee, or 5 lakhs, 50 lakhs, or 5 crore, you are consumer only, right? Protection of the interests of all the consumers is the first main point. So for that, what we have to do, we have to establish authorities. But already authorities are there. Then why again na? To find out a way for timely administration. சீக்கிரமா இந்த கேஸ் முடிச்சு நான் ஆன்லைன்ல வாங்கி ஒரு கிளிக்ல வாங்கின ஒரு விஷயத்துக்கு மறுபடியும் ஒரு 5 வருஷம் வெயிட் பண்ணி என்னால ஜட்மெண்ட் வாங்க முடியாது. So that is the reason why I need some solution. Settlement of consumer disputes. That's where this mediation and all has been introduced now, like by the new act. So let's see. Actually, it is yet to be implemented, but still we have to see how this is going to get implemented in a very effective way. But the basic idea why this act has been brought in is for this reason, right? We need to find out a way for effective and speedy disposal of consumer disputes. Then only we will get more consumers approaching the forum. இப்போ இன்னைக்கும் நம்ம வீடுகள்லயே ஏதாவது ஒரு ப்ராப்ளம் ஏதோ ஒன்று ஃபேஸ் பண்றோம்னா நம்ம ஒரு we don't approach the judiciary or the consumer forums very easily. எடுத்தோடனே இது கன்சியூமர் இஷ்யூ நான் போறேன் அப்படின்னு சொல்லி கன்சியூமர்ஸ் கேள்வி கேட்கவே இன்னும் தொடங்காத மாதிரி தான் இருக்கு, ரைட்? நம்ம பார்க்குற எல்லா கன்சியூமர்ஸும் கன்சியூமர் கோர்ட் வரைக்கும் போய் ஆர் கன்சியூமர் ஃபோரம் வரைக்கும் போய் கேஸ் போடுவாங்களா அப்படின்னு நீங்கள் ஒரு சர்வே எடுத்தீங்கன்னா அட்லீஸ்ட் 100, if you ask 100 people, 50 at least less than 50 will tell, or less than 50 only will tell that they will go for a case. Beyond that, people will tell, இதுக்கெல்லாம் போனா நேரம் ஆகாதா, இது உடனே ஜட்மெண்ட் வருமா? ஸோ தட் இஸ் அவர் பேசிக் ப்ராப்ளம். இன்ஃபேக்ட் இது வந்து நான் ஒருவேளை உங்ககிட்ட பேசும்போது யூ மே ஃபீல் தட் ஐ எம் டெல்லிங் தட் இட்ஸ் நாட் ஒர்க்கிங் வெல். ஆக்சுவலி இட் இஸ் ஒர்க்கிங் வெரி வெல். But due to, as somebody has asked in the previous session, lack of infrastructure, lack of appointments in the proper time, everything matters for that effective administration. So when we talk about effective administration, it should be a wholesome approach. It is not only the officers who are sitting here. In fact, you people who are sitting in front of me or listening to me, you are all efficient. That's why you are sitting here to learn more. Correct? இது இல்லாத ஆஃபீஸர்ஸ் அல்லது வராத ஆஃபீஸர்ஸ் ஆர் இங்கே வராத ஆஃபீஸர்ஸ் இல்லை, அப்பாயிண்டே பண்ணப்படாம எத்தனையோ ஃபோரம் இருக்கு. பிகாஸ் once when we visited with our students to the consumer forum in Chennai, Mylapore, some district commission or something, when we went, we could see that day there was no sitting. அப்படின்னா ஏன்னு கேட்டப்போ இல்லை அது அப்பாயின்மெண்ட் நடக்கல, அவர் இல்லை, இவர் இல்லை, மெம்பர் இல்லை, சம்திங் இட் வாஸ் டோல்ட். ஸோ we find that lack of infrastructure and proper appointments or delay in appointments also is one of the reason for the lack of effective administration. So all this must be set right. That is the aim of this legislation. Now, before going to this, the serious definitions like that, one question has to be answered whenever there is a new legislation coming up. எப்பயுமே ஒரு புது சட்டம் வந்ததுன்னா அப்ப இதுக்கு முன்னாடி இருந்த சட்டங்களும் இதுக்கு முன்னாடி அந்த சட்டத்துல ஃபைல் பண்ணப்பட்ட கேசஸ் எல்லாம் என்ன ஆகும்? இது சாதாரண பொதுமக்களோட ஒரு சின்ன கேள்வி. பட் ஆஸ் ஆஃபீஸர்ஸ் we also should know that effect of cases filed before the coming into force of the new act. அதாவது 1986 சட்டத்தின் நுகர்வோர் பாதுகாப்பு சட்டத்தின் கீழ் ஏற்றுக்கொள்ளப்பட்ட வழக்குகள் என்ன ஆகும் இந்த சட்டம் வந்ததுனால? Actually, there are numerous cases filed, we all know, at all levels, state, district, national, everywhere it is filed. So in that case, you have to read section 107, last section of the Consumer Protection Act 2019. இப்போ வந்திருக்க சட்டத்தோட கடைசி section read with section 6 of the General Clauses Act. If you read that, it says any legal proceeding that has already started under the existing legislation shall not get affected by the repeal of the act. So இந்த பழைய சட்டத்துல தொடுக்கப்பட்ட வழக்குகள் புது சட்டம் வந்ததுனால it will not happen anything. It will be taken over as it is and it will be completed by the new forum. Correct? So 107 read with Section 6 of the Consumer Protection Act 2019. Two legislations will be referred that. The other one is General Clauses Act. In fact, இதை பேஸ் பண்ணி there's a judgment also, SEBI versus Classic Credit Limited, Securities Exchange Board of India versus Classic Credit Limited, and also Sajad Ahmad Malik and others versus Divisional Manager, National Insurance Company Limited and another. In these two cases, courts have already told that June 22, 2020, this judgment. So they have already told in this judgment that a combined reading of Section 107 Consumer Protection Act and General Clauses Act Section 6 reveals that any legal proceeding that has already started under the existing legislation shall not get affected by the repeal of the act. Right? So this, I think it's a very general, as officers you have already known, but for the people, public, this will be a big question. நான் அப்பவே கேஸ் போட்டேன், இப்போ அந்த சட்டம் இல்லைன்னு சொல்லிட்டீங்க, அப்போ என் கேஸ்லாம் என்ன ஆகும்? So for that only this point has been clarified here. I hope I am audible once again.
Yes ma'am.
Yeah, hope I'm not very fast or I'm not very, I'm clear or
very clear. Please go.
போயிட்டு இருக்கு இல்லையா? ஓகே. ஸோ ஏன்னா இது ஆன்லைன்ன்றதுனால திரும்ப கேட்டுக்க வேண்டியது இருக்கு. ஏன்னா நாங்கள் கம்ப்யூட்டர்கிட்ட பேசிட்டு இருக்க மாதிரியே இருக்கும், எங்களுக்கு யாராவது கேட்குறாங்களா அப்படின்னு இருக்கும். ஸோ தட்ஸ் வை ஐம் ஆஸ்கிங், சாரி ஃபார் தட். ஸோ கன்சியூமர், very basic definitions is very, very important because I already told it is not only as officers, but as consumer, I should know who am I, right? Whether I can file a case is itself a big question. Section 2, Clause 7I. So it's defined in that act, and you will see the definition in a big word, but I have just split it into points. One by one, if you go, consumer is a person who buys any goods for a consideration, first point. It includes any user of such goods other than a person with the approval of the person who purchased it. Third point, it does not include a person who obtains goods for resale or for any commercial purpose. And what is commercial purpose is explained there. And what is buys any goods are also explained there. Now let me explain this point. It's very easy when we read, when we, even to students we will tell, படிக்கும்போது ஓ இப்போ என்ன பொருள் வாங்கினா கன்சியூமர் அவ்வளோதானே அப்படிம்பாங்க. But it's not like that. Any person who buys any goods for consideration. இதுல buys any goods அப்படின்றது எக்ஸ்பிளைன் பண்ணணும், consideration அப்படின்றதும் எக்ஸ்பிளைன் பண்ணணும். And the second point is, இப்ப நான் ஒரு பொருள் காசு கொடுத்து விலை கொடுத்து வாங்கினால், ஒரு பொருளை பெறுபவர் அப்படின்னு சொல்றதுக்கும் ஒரு பொருளை வாங்குபவர் அப்படின்னு சொல்றதுக்கும் வித்தியாசம் இருக்கு. கரெக்ட்? வாங்குபவர் அப்படின்றது கன்சிடரேஷன் கொடுத்து வாங்குபவர், ஏதோ ஒன்று கொடுத்து, அது 5 ரூபா பொருளோ 5 கோடி பொருளோ, பட் ஐ ஹவ் பெய்ட் அண்ட் ஐ ஹவ் பர்ச்சேஸ்ட் இட். பெறுபவர் அப்படின்னா யார்கிட்ட இருந்தோ வாங்கிட்டார், அதுக்கு கன்சிடரேஷன் கொடுத்துருக்கணும்னு அவசியம் இல்லை. இங்க வந்து நம்ம வாங்குபவர் தான் ஸ்ட்ரெஸ் பண்றோம், ரைட்? எனிபடி who buys any goods for a consideration. Now, if I purchased a product, for example, I brought a chocolate, I took home, my son ate it. Suppose avan da saaptan. So he used that product which I purchased with the permission of me, with the approval of me, then he is also consumer only. Say இப்போ சாக்லேட்ல ஏதோ ஒன்று ஆயிடுச்சு, ஏதோ ஒன்று நல்லா இல்லை, அல்லது அவருக்கு அலர்ஜி வந்துருச்சு, ஏதோ ஒன்று வந்துருச்சு, அதனால ஏதோ நடந்தது. So then whether he is a consumer? Yes, he is also consumer. Because the definition says it includes any user of such goods other than a person with the approval of the person who purchased it. So பெற்றவர் அந்த வாங்குபவரை தவிர வாங்கி அவரோட சம்மதத்தோட உபயோகித்தவர், right? With the approval of the person who purchased it. That is the second people who come within the definition of consumer. So actually இவங்க தான் anybody who buys any goods for consideration. Number 2, anybody who uses the product with the approval of the person who purchased it. 2 clause 7 clause 1. பட் இதுல என்னன்னா இது இதே டெஃபினிஷன் தானே 1986 ஆக்ட்லயும் இருந்தது. என்ன பெரிய வித்தியாசம் அப்படின்னு ஒரு கொஸ்டின் வரலாம். ஆல்ரெடி இருந்தது கன்சூமர் டெஃபினிஷன், அப்பயும் இருந்தது. இட் இஸ் நாட் நியூ. பட் there's one line which say it does not include a person who obtains goods for resale or for any commercial purpose. இந்த டெஃபினிஷனும் அப்பயே இருந்தது. பட் 86ல வரல. அப்புறம் அமெண்ட் ஆயெல்லாம் கமர்ஷியல் பர்பஸ் எல்லாம் இன்க்ளூட் ஆச்சு. who obtain goods for resale or for any commercial purpose. நான் ஒரு பொருளை வாங்கி இன்னொருத்தருக்கு விற்கிறேன். நான் விற்கிறதுக்காக தான் வாங்குறேன்னா வெதர் ஐ ஆம் அ கன்சியூமர் அப்படின்ற ஒரு கொஸ்டின் வரும். ஆக்சுவலா 1986 ஆக்ட்ல கூட கமர்ஷியல் பர்பஸ்ன்ற வார்த்தை இருந்தது. பட் வாட் இஸ் கமர்ஷியல் பர்பஸ்ன்னு எக்ஸ்பிளைன் பண்ணல. அது 2019 ஆக்ட்ல கிளாரிட்டி வந்திருக்கு இப்போ. ரைட்? Commercial purpose means which does not include use by a person of goods bought and used by him exclusively for the purpose of earning his livelihood by means of self-employment. ஏன்னா 1986 ஆக்ட்ல கமர்ஷியல் பர்பஸ் சொல்லியிருந்த போது நிறைய ஒரு டவுட்ஸ் இருந்தது. சில கேசஸ்ல ஆக்சுவலி உங்களை மாதிரி ஆஃபீஸர்ஸ் அதை நல்லா கிளாரிஃபை பண்ணியிருந்தாங்க. பட் ஒரு கேஸ்லேயும் மாறிக்கிட்டே இருக்கிற ஒரு பிரச்சனை வந்தது. ரைட்? ஃபார் எக்ஸாம்பிள், இப்போ நான் என் வீட்டுக்கு தேவையான என் பிள்ளைங்களுக்கு படிக்கிறதுக்கோ எதுக்கோ ஜெராக்ஸ் எடுக்கிறதுக்காக ஒரு ஜெராக்ஸ் மெஷின் வாங்குறேன்னு வச்சுப்போம். ஐ எம் அ கன்சியூமர் டெஃபினெட்லி பிகாஸ் ஐ பர்ச்சேஸ்ட் இட். பட் சப்போஸ் நான் ஒரு ஜெராக்ஸ் கடை வைக்கிறதுக்காக ஒரு ஜெராக்ஸ் மெஷின் வாங்கியிருக்கேன். அதை வச்சு தான் என்னோட லைவ்லிஹுட் போயிட்டு இருக்கு. வெதர் ஐ ஆம் அ கன்சியூமர். அண்டர் த ப்ரீவியஸ் ஆக்ட், when people were telling commercial purpose was interpreted in some of the cases as அவர் வந்து ஜெராக்ஸ் கடை தானே வச்சிருக்காரு, he is making money out of that, no, so he cannot be a consumer. Like that it went. But court clarified and said no, commercial purpose வாங்கி விற்கிறவர் அல்லது ஒரு பொருளை வைத்து பணம் பெறுபவர் அல்லது வியாபாரம் செய்பவர் அவர் கன்சியூமர் இல்லதான். ஆனா ஒருவேளை அந்த பொருள் தான் அவரோட வாழ்க்கைக்கு ஆதாரம், livelihood, then or for self-employment. இப்போ நான் ஒரே ஒரு ஜெராக்ஸ் மெஷின் வாங்கி அதை வச்சு ஒரு கடை நடத்தி டெய்லி எத்தனையோ பேர் வந்து எடுக்கிறாங்க, அதுதான் என்னோட லைவ்லிஹுட்னா அந்த மெஷின் 2 நாள் ஓடலைனாலும் என்னோட லைவ்லிஹுட் பாதிக்கப்படும். Right? I will not earn myself because I am earning only with that. So then I also should be included within the term consumer. So those who purchase goods for earning livelihood or for self-employment, even though it will look like commercial purpose, it is not falling within the definition of commercial purpose. In the clarity 2019 Act la vandirukku. Right? I hope I have clarified that position. Hope it's clear. And another point, buys any goods. வாங்குபவர் ஃபர்ஸ்டே சொன்னேன். பட் இந்த வாங்குபவர்ன்றது நான் ஃபர்ஸ்ட் ஒரு இன்ட்ரோல சொன்னேன் இல்லையா, the definitions have been expanded. I told you how it has been expanded na இன்னைக்கு buys any goods அப்படின்றது it is both offline and online transactions or by tele shopping or direct selling or multi-level marketing. இது எதுவுமே 1986 ஆக்ட்ல இல்ல. ஆஃப்லைன் ஆன்லைன் அதெல்லாம் கிடையாது. பைஸ் மீன்ஸ் கடைக்கு போய் வாங்குபவர். இப்போ it has been expanded to include offline, online, teleshopping, direct selling, multi-level marketing, anything. So it has been included, right? So that's where we have expanded. இப்போ இன்னுமே இந்த டெஃபினிஷனுக்கு ஒரு கிளாரிட்டி தேவைப்படுது. பிகாஸ் குட்ஸ் அப்படின்னு சொல்லிட்டோம். What is this goods? It's very, very important definition as far as the consumer is concerned, because goods na என்னன்னு தெரிஞ்சாதான் buys any goods for consideration. அப்பதான் நான் கன்சியூமரா இல்லையானே முதல்ல ஃபிக்ஸ் பண்ணிக்க முடியும். Goods means every kind of mobile property and includes food as defined in clause J of subsection 1 of section 3 of the Food Safety and Standards Act 2006. Right? So already Food Safety and Standards Act 2006ல ஃபுட்னா என்னன்னு டிஃபைன் ஆயிருக்கு. இங்க என்ன சொல்றாங்கன்னா goods means all kinds of mobile property. That's all. Easy to understand. All kinds of mobile property, but it will include food also. ஃபுட்னா என்ன? that act. Already it is defined. Food Safety and Standards Act 2006 is already defining food, right? So in the definition of consumer, we need to split these definitions into what do you mean by buys any goods? What do you mean by consideration? What do you mean by goods? இதெல்லாம் define ஆனதான் வந்து consumer definition complete ஆகுது. But as officers, I think, I feel, I don't know, I must learn from you practically. Every time, in every case, I think what is the consumer need to be defined. Then only you can give justice, correct? So, or you can give the judgment. So, before going to any case, I think what is consumer needs to be clarified. I think both the sides will be speaking, I'm a consumer. The other side will tell, no, I'm not. He's not a consumer. So, that's how it goes. So, goods, mobile property, and food. It includes food also. And now what is food is already defined the and the section is split பண்ணிருக்கேன். Food Safety Standards Act la what is food is told. Food means any substance whether processed, partially processed or unprocessed which is intended for human consumption. சிம்பிளா சொல்லணும்னா சாப்பிடுற பொருள், அதாவது மக்கள் உபயோகிக்கும் ஐ மீன் உணவுக்காக அல்லது சாப்பிடலாம் அப்படின்ற எல்லா பொருளும் ஃபுட்டோட டெஃபினிஷனுக்குள்ள வருது. ஃபர்ஸ்ட் திங். Second one includes primary food to the extent defined in clause the Z of the what do you call genetically modified or engineered food or food containing such ingredients. So again, they have defined ZK. There's already a definition in the act. If you go to the definition clause, you will find section 2 la, like genetically modified or engineered food or food containing such ingredients. இப்போ even சார் பேசும்போது கூட சொன்னாங்க, adulteration இல்லாம ஒரு ஃபுட்டும் இல்லைன்ற ஒரு ஸ்டேஜ்ல நம்ம இருக்கோம். பட் 1986 ஆக்ட் வரும்போது நமக்கு adulteration மட்டும்தான் பிரச்சனை. We had Food Adulteration Act also already, in fact. ஸோ ஒரு பாலில் தண்ணி கலக்கலறது இந்த ஆரம்பிச்சு adulteration is a big problem. எல்லாத்துலேயும் இப்போ எல்லாத்துலேயும் adulteration இருக்கு, நமக்கு தெரிஞ்சே தான் நம்ம யூஸ் பண்ணிட்டு இருக்கோன்ற மாதிரி இருக்கு. பட் நவ் அப்பார்ட் ஃப்ரம் adulteration, there's a new problem coming into this whole world. I think genetically modified food. I think marketல நம்ம கண்டிப்பா நிறைய பேர் நம்ம இப்போ யூஸ் பண்றோம், பார்த்துருக்கோம். It started with tomato. தக்காளினா நாட்டு தக்காளி தான் நமக்கு தெரியும். இப்போ அது வேற மாதிரி பெங்களூர் தக்காளின்னு ஆரம்பிச்சோம், பெரிய கத்திரிக்காய் ஆரம்பிச்சோம். ஸோ லைக் தட் எவ்ரிதிங் இஸ் பிகமிங் நாட் த யூஷுவல் திங்ஸ். அன்யூஷுவல் திங்ஸ் எல்லாமே somewhere it is genetically modified goods தான். But as a consumer, I don't know whether it is genetically modified or not. In European countries and all, what they do is they're also genetically modified is there. GM foods னு ஷார்ட்டா சொல்லுவாங்க. பட் அவங்க அங்க என்ன ரூல்ஸ் கொண்டு வந்திருக்காங்கன்னா, GM foods-ஆ இருந்தா it should be informed to the consumer. நீங்க போட்டுருங்க, போர்டு போட்டுருங்க, this is GM food. வேணா அவங்க வாங்கிக்கிட்டோம். I have a choice to choose between the normal food and the genetic modified goods. But here in India, if you go to a supermarket or if you go to a vegetable market or somewhere, எல்லாம் ஒன்றா தான் இருக்கு. வயலட் கலர்ல முட்டைக்கோஸ்லாம் இருக்குல்ல, லைக் பார்த்தாலே பயமா இருக்கு, எந்த கலர்ல எல்லாம் இருக்கா அப்படின்னு இருக்கு. ஒரு அன்யூஷுவல் கலர்லாம் இருக்கு. அன்யூஷுவல் திங்ஸ் ஆர் தேர். பட் இட் இஸ் நல்லதும் இருக்கு, இல்லைலாம் சொல்ல முடியாது. ஜெனட்டிக்கலி மாடிஃபைட் இஸ் ராங் அப்படின்லாம் சொல்ல முடியாது. பிகாஸ் த டிஎன்ஏ இட் செல்ஃப் இஸ் பீன் சேஞ்ச் இன் டு தட் ப்ராடக்ட். பட் நம்ம நல்லா நோட்டீஸ் பண்ணோம்னா, the more this type of new goods have come into the market, the more number of medical issues have come to our society. The more number of health problems have come to our society. We can see that. Today we will not know. Maybe another 10 years கழிச்சு சொல்லுவோம், இதெல்லாம் அது சாப்பிட்டதுனால வந்த ஒரு effect. I think we have some specialized people called gastroenterologist. இப்போ ஒருத்தர் புதுசா, I mean புதுசு இல்லை, ரொம்ப நாளா இருக்காங்க. You will see that board everywhere, and if you go to such doctors, you will find எந்த டாக்டரே இல்லாத கூட்டம் அங்க இருக்கு. காரணம் என்னன்னா, இதெல்லாம் யூஸ் பண்ண ஆரம்பிச்சிட்டோம். As consumers, the more number of people are affected. Because in India, there's the problem. Immediately, we won't raise anything. After 10-15 years only, we will identify that something is wrong with the product. அப்ப the 10-15 years யூஸ் பண்ண கன்சியூமருக்கு யார் பதில் சொல்லுவான்னு தெரியல. Right? We don't know. For example, noodles. நூடுல்ஸ் இஷ்யூ வந்தப்போ ஒரு நம்ம ஐ மீன் ஐம் என்னோட சைல்டுஹுட்ல இருந்து யோசிச்சா கூட நூடுல்ஸ் இருந்தது. 2 மினிட்ஸ் 2 மினிட்ஸ்னு அட்வர்டைஸ்மெண்ட்லாம் காமிச்சு நூடுல்ஸ் வாஸ் வெரி பாப்புலர். பட் நவ் சம் இயர்ஸ் பிஃபோர் இட் கேம் தட் அதில் வந்து அதோட சம்திங் இஸ் மிக்ஸ்டு, இட் இஸ் நாட் குட் ஃபார் த பிரெயின், etc. etc. So many controversies came. Of course, controversies are settled and the companies are moving on. அது வேற. பட் இந்த கான்ட்ரவர்சிஸ் இப்போ வந்தப்போ பிரெயின் அஃபெக்ட் பண்ணும் அப்படி இப்படின்லாம் சொல்றீங்க. அப்போ இந்த 25 இயர்ஸ் யூஸ் பண்ணவங்களுக்கு என்ன பதில்? அந்த 25 இயர்ஸ் குழந்தைங்கள்ல இருந்து சாப்பிட்டவங்க. ஏன்னா நூடுல்ஸ் ஹஸ் பீன் யூஸ்ட் ஃபார் so many years. Not only noodles, Pepsi, Coca-Cola, when that issue came also, it was a very heated issue. Pepsi, Coca-Cola எல்லாம் வந்து some amount of pesticide is being mixed or எவ்வளோ அமௌண்ட் இருக்கு அப்படின்னு இந்தியாவில் நம்ம டிஸ்கஸ் பண்ணிட்டு இருந்தோம். லைக் எவ்வளோ அமௌண்ட் பெஸ்டிசைட் இதில் கலந்துருக்கு அப்படின்றது பெரிய இஷ்யூவாக டிஸ்கஸ் பண்ணிட்டு இருந்தோம். பட் என்னோட எகெயின் தாழ்மையான கருத்து இந்த ஃபோரத்தில் சொல்லலாமான்னு எனக்கு தெரியல. பட் ஐ ஜஸ்ட் வாண்டட் டு எக்ஸ்பிளைன், பெஸ்டிசைடு எந்த அளவாக இருந்தால் என்ன, பெஸ்டிசைட் இஸ் நாட் யூஸ்டு ஃபார் கன்சம்ஷன். அது 0.5 இருந்தா என்ன, 0.10 இருந்தா என்ன, 200 இருந்தா என்ன, யூ ஆர் நாட் சப்போஸ் டு யூஸ் பெஸ்டிசைட். பெஸ்டிசைடு மீன்ஸ் இட் இஸ் மென்ட் ஃபார் பெஸ்ட், நாட் ஃபார் ஹியூமன் கன்சம்ஷன், ஐ திங்க். But unfortunately, again, even Pepsi, Coca-Cola has been sold in this country. அவங்களுக்கு எந்த பிரச்சனையும் வரல. இப்போவும் அந்த கம்பெனிஸ் மூவ் ஆன் பண்ணிட்டே தான் இருக்காங்க. Now, when I say companies, இன்னும் ஒரு விஷயத்தை இந்த ஃபோரத்தில் சொல்லணும்னு நினைச்சேன். இன்னைக்கு இந்திய நுகர்வோர்கள் அவங்க சந்திக்கிற பிரச்சனை என்னன்னா, it is not Indian companies alone. We are facing multinational corporations in front of us. So that's the biggest challenge for any consumer forum or any officers like you to execute it, because the case is filed between an ordinary consumer like me against a multinational corporation. So whether I will be able to prove my case before the consumer forum is itself a biggest challenge which I will be facing, right? Or I means any ordinary consumer. Now we're coming back to the definition. So genetically modified goods is the biggest challenge which any consumer or any forum is facing. Third one is infant food. Of course, it includes everything. Packaged drinking water, alcoholic drink, chewing gum, any substance including water used into the food during its manufacture, preparation or treatment. All this is falling within the definition of food. What the other point is, it does not include any animal feed, live animals, unless they are prepared or processed for placing on the market for human consumption, because that's a different legislation again. Plants prior to harvesting, drugs and medicinal products, cosmetics, narcotic or psychotropic substances. Because for this we have a separate legislations anyways. Narcotic we have, cosmetics, Drugs and Cosmetics Act we have. Like that separate legislations are there. So that's the reason probably this food definition does not include that. And the central government, apart from this, may declare by notification in the official gazette any other article as food for the purposes of this act, having regards to its use, nature, substance, or quality. So it's not a conclusive definition. They can declare, the central government has a right to declare something as food also. And moving on, so our consumer definition will get completed here only, including food, right? Buys any goods for consideration. And now coming to the most goods in சொல்லும்போது, ஏன்னா கன்சியூமர் டெஃபினிஷனை நீங்க ரெண்டா பிரிக்கலாம், குட்ஸ், சர்வீசஸ். குட்ஸ்ன்ற வேர்டு டிஃபெக்டிவ் குட்ஸ், சர்வீசஸ்க்கு டெஃபிஷியன்சி ஆஃப் சர்வீசஸ். ஸோ தட்ஸ் ஹவு இட்ஸ் டிஃபைன். நம்ம இப்போ இந்த குட்ஸ் மட்டும் தான் பார்த்துட்டு இருக்கோம். Goods definition we saw, then we have defective goods. When we say defective goods, first we need to know what is defect. Defect is defined in section 2 clause 10 of the Consumer Protection Act 2019. Very simple. We already know, no big changes have come. I think 86 Act also had all these problems. Defect means any fault, imperfection or shortcoming in the quality, quantity, potency, purity or standard which is required to be maintained by or under any law for the time being in force or under any contract, express or implied, or as is claimed by the trader in any manner whatsoever in relation to any goods or product, and the expression defective shall be construed accordingly. Very simple. It's talking about quality. That's where every quality check comes in. Quantity, in fact, the ordinary Indian consumer, when I mean ordinary, I am not talking about small or சாதாரண பொருள் வாங்குறோம் அப்படி இல்லை, ஈவன் ஒரு நாட் அ பிராண்டட் கன்சியூமர், அதுதான் நான் மீன் பண்றேன். அப்பார்ட் ஃப்ரம் அ பிராண்டட் கன்சியூமர் ஆர் சம்திங், ஈவன் இஃப் யூ கோ டு அ ஸ்மால் ஷாப் அண்ட் கெட் 1 லிட்டர் அல்லது ஒரு பெட்ரோல் 1 லிட்டர் அப்படின்னு சொல்லி போட போகும்போது நமக்கே நிறைய வாட்டி டவுட் வந்திருக்கு, அவ்வளோதான் இருக்குமா, 1 லிட்டரா இது, நிஜமாவே 1 லிட்டர் கிடைச்சதா எனக்கு? ஸோ தேர் கம்ஸ் த குவான்டிட்டி ப்ராப்ளம், பொட்டன்சி, because every time a trader says or supplier says that this product will work like this, but அந்த பொட்டன்சிக்கு ஒர்க் பண்ணுதா? நிஜமாவே is it working according to what he said? Purity, where in gold and things like that, very important, purity becomes a problem. Or the standard which is required, like we know in India we have ISI, AGMARK, etc., we have so many things. So they all, any law which tells that this is the standard which you have to maintain for this product, then that has to be maintained. Otherwise that is also considered to be defective only. Or under any contract, say between the buyer and the seller, suppose the buyer, the contract entered into between the buyer and the seller, in the contract there is a clause saying that this will be the quality I will be giving you. யாரும் ஃபிக்ஸ் பண்ணல, நான் ஃபிக்ஸ் பண்ணி நானும் உங்களுக்கும் பேசிக்கிறோம். பையர் அண்ட் த செல்லர் சப்போஸ் சேஸ் தட் நான் பொருள் கொடுக்குறேன், இந்த பொருள் இந்த குவாலிட்டியில இருக்கும், இப்படி இருக்கும், திஸ் இஸ் த ஸ்டாண்டர்ட் விச் ஐ ஆம் கிளைமிங் பை த ட்ரேடர், தென் தட் ஆல்சோ ஹேஸ் டு பி கமன். ஃபைனல் ப்ராடக்ட்ல அது வந்திருக்கணும், அப்படி இல்லைன்னா அதுவும் டிஃபெக்டிவ் தான். And all this is considered to be defective under section 2 clause 10 of the Consumer Protection Act 2019. So here when we say defective, every day I think most of the cases, whenever we talk about goods, we will come across defective goods now. For that only cases are being filed under before the forum. Anything starting from any normal product to biggest one, yes, whether it is goods is becoming a big issue. And once a forum decides the issue that he is the consumer, the next issue to be solved is, suppose he is coming with a defective goods, then is he coming within this definition of this defective? Because the opponent counsel, suppose I am a consumer filing a case that it is defective, then the opposite party will be saying, no, this does not fall within what we call as defective. இது அவங்களா ஏதோ பண்ணிட்டாங்க, அல்லது இப்படி நடக்காது, நடந்திருக்கலாம், எக்ஸெட்ரா எக்ஸெட்ரா. ஸோ இதை நாங்கள் டிஃபெக்ட்னு அந்த டெஃபினிஷனுக்குள்ளேயே வரல, அல்லது நாங்கள் இப்படி சொல்லலை விற்கும் போது, இட் கேன் பி anything, right? So that has to be solved in the next issue. The second issue will be whether it is defective, if it is goods. Now, I just took up some examples because in the modern era, ஒரு பொருள் உடஞ்சிருச்சு அல்ல வந்துருச்சு, இது எல்லாமே டிஃபெக்டிவ் தான், உடஞ்சே வருது. இப்போ ஆன்லைன்ல வாங்குறதுலோட பிரச்சனை என்னன்னா, many times when we order goods, the goods will come, but it will come in a damaged condition when we purchase online. So that becomes defective. Or that and all we know. But some issues which has arose, new cases these are, Amit Arora and another versus Vatika Limited. In this case, the issue was whether the complainant who booked the apartment was a consumer. So consumer definition ku nama thirumba poi yosichona, anybody who buys the goods for consideration. And another problem is idu weed, like building construction contractors, etc. Now the opposite parties in this case had failed to prove the commercial purpose. So in the commercial purpose என்ற வார்த்தைக்காக தான் இந்த case, and therefore the complainant is a consumer under the Consumer Protection Act. It may be useful to you because you people are daily enforcing. It has been held that when somebody raises the question of commercial purpose, actually the opposite party has to prove that the complainant will fall within that definition. Commercial purpose ilya, whether it was purchased for, because the definition of consumer says if it is for commercial purpose, then he is not a consumer. First of all, நீங்க கேஸே போட முடியாது, நீங்க கன்சூமரே இல்லை, பிகாஸ் இது கமர்ஷியல் பர்பஸ். ஸோ அது யார் ப்ரூவ் பண்ணணும்னா, Complainant illa, opposite party. Because opposite party only will be defending, saying, இது கமர்ஷியல் பர்பஸ்க்குள்ள வரும், அதனால இவர் கன்சியூமர் இல்லைன்றுவாங்க. அப்போ நீங்கள் ப்ரூவ் பண்ணுங்க. நீங்கள் பண்ணலை, அதனால ஹீ இஸ் அ கன்சியூமர்னு திஸ் கேஸ் ஹெல்ட். அண்ட் ஒன் மோர் இஸ் Imperia Structures Limited versus Anil Patni and another. Here the other problem is now we have RERA, that is our regulatory authority on this all this home buyers, இவங்க எல்லாருமே அதில் தான் போகிறாங்க, right? Real Estate Regulatory Authority. So the question was in this case whether there is a need for interference by the court in the conclusions drawn by the National Law Commission. It was held that the judgment was passed in favor of the home buyers, upholding the decision of the National Consumer Dispute Redressal Commission. And it was also held, a very important point which was held here is, RERA and Consumer Protection Act are two different legislations. And despite ongoing cases at RERA, Consumer Forum will always have the power to entertain cases wherein the home buyers qualify as consumers within the definition mentioned under the Consumer Protection Act 1986. இங்கே நான் 1986 ஏன் சொல்றேன்னா, இந்த ஜட்மெண்ட் தான் லேட்டஸ்டாக வந்தது. இட் வாஸ் ஃபைல்ட் அண்டர் த ப்ரீவியஸ் ஆக்ட். அதுக்கு டெசிஷன் இப்போ சொல்லியிருக்காங்க. ஏன்னா ரெராவும் இப்போ தானே வந்தது. பழைய கேஸ் அப்போவே ஃபைல் ஆனது. ஆஸ் ஐ டோல்ட் யூ, அது பெரிய ட்ரான்ஸ்ஃபர் ஆகி இப்போ இங்கே வந்து just I am sorry that I did not put the citation. If possible, I'll get you the citations tomorrow. I think RERA வந்தப்போ அந்த கன்ஃபியூஷன் அதான். RERA இருக்குல்ல, நீங்கள் அங்கே போய்க்கோங்க. Opposite party will normally argue like that only, you know. But the court said no, even though RERA is there, that are two different parallel legislations, we don't say no, but still they will qualify as home buyers. So they are consumers. That's how it was held here. இது ரெண்டுமே வந்து இந்த housing or real estate, அது சம்பந்தமான cases. And commercial purpose. Once again, this is Sheila and another versus Parswant Developers Limited. This case, commercial purpose clarity oda explain பண்ணியிருக்காங்க. Right? Very beautifully it has been explained by the court, because they have explained whenever you want to decide on whether it is a commercial purpose, keep this in mind என்ற மாதிரி point கொடுத்துருக்காங்க. So generally commercial purpose is understood to include manufacturing, industrial activity or business to business transaction between commercial entities. So the purchase of the good or service should not have a close and direct nexus with a profit generating activity. உதாரணத்துக்கு, சப்போஸ் நான் ஒரு கம்பெனி முதலாளி, நான் என் வீட்டுக்கு ஒரே ஒரு கம்ப்யூட்டர் வாங்கினேன், ஐ எம் அ கன்சூமர் ஒன்லி. நீங்க கம்பெனி முதலாளி, அதனால நீங்க கன்சூமர் இல்லை அப்படின்லாம் சொல்லக்கூடாது. அதுல டிஃபெக்டிவ் இருந்தா. பட் நான் என்னோட கம்பெனி ஆஃபீஸ் தேவைக்காக 100 கம்ப்யூட்டர்ஸ் வாங்கியிருக்கேன்னு வச்சுக்கோங்க, then I may not fall within this definition of consumer, because close nexus with the profit generating activity, right? Then it is called as commercial purpose. இது ஒரு நல்ல ஒரு நமக்கு அதை டிஃபைன் பண்ணிக்கிறதுக்கு அல்லது எக்ஸ்பிளைன் பண்ணிக்கிறதுக்கு it will help us a lot. நமக்கே கூட, ஐயோ நான் கம்பெனி முதலாளி, அதனால எனக்கு நான் எங்கள் வீட்டுக்கு ஒரு ஃப்ரிட்ஜ் வாங்கியிருக்கலாம், அதனால சம் டிஃபெக்டிவ், அதுக்காக நீங்கள் கம்பெனி முதலாளி அதனால நீங்கள் வந்து போடக்கூடாதுன்னு அர்த்தம் ஒன்றும் இல்லை. That is a different one. So there should have a close nexus between profit generating activity. இதை வைத்து, இந்த பொருளை வைத்து நீங்க என்ன பண்ணீங்க, whether you generated profit out of this product which you purchased. Third point, the identity of the person making the purchase or the value of the transaction is not conclusive to the question of whether it is for a commercial purpose. எவ்வளோ ரூபா, யாரு, அதெல்லாம் பிரச்சனை இல்லை. It's not the value, that's what they say. It is to be seen whether the dominant intention or dominant purpose for the transaction was to facilitate some kind of profit generation for the purchaser or their beneficiary. So, நான் ஏற்கனவே சொன்ன எக்ஸாம்பிளே இதுக்கு எடுத்துக்கலாம். ஸோ நான் ஒரு பொருள் வாங்கினேன்னா 100 பொருள் வாங்கினேன்னா அது பிரச்சனை இல்லை. அந்த 100 பொருள் வச்சு நான் என்ன பண்ண போறேன், that is the point. And if it is found that the important purpose, that is dominant purpose, இதை எதுக்கு நான் யூஸ் பண்ண போறேன், அதான் question. So dominant purpose behind purchasing the goods or services was for personal use and consumption of the purchaser or their beneficiary or is otherwise not linked to any commercial activity, the question of whether such a purchase for the purpose of generating livelihood by means of self-employment need to be looked into. So basically, commercial purpose na industrial activity, manufacturing activity, business to business transactions. Yes. பட் சப்போஸ் ஒருத்தர் அந்த பொருளை வாங்கி அந்த பொருளை வச்சுதான் அவர் வந்து வாழ்க்கையே நடத்திட்டு இருக்காருன்னா, then we need to look into the topic of commercial purpose, livelihood, self-employment, etc. So I think this case explained very beautifully the definition of commercial purpose or what is commercial purpose in simple points that judgment had that. So I just put the important points. Hope it will be useful. And then coming to now coming to goods. So goods in இடத்துல இவ்வளோ விஷயங்கள், that is we need to look into buys any goods, what is goods, what is commercial purpose, these needs to be looked into. Now coming to same consumer definition ஓட second part வேணும்னா சொல்லலாம், consumer of services. Almost the same definition like goods, but a person is a consumer of service if he hires or avails any service for a consideration. Buys any service illa, hires or avails any service. So that's the terminology difference which is used for goods and services. And it includes any person, same thing, who has availed such services with the approval of the person who hires or avails. And it does not include commercial purpose, same story. And again, same offline, online, everything, electronic means, teleshopping, everything. It can be by any way. Only difference is he buys any services, it is hires or avails any service. Because when we say service, we use service actually. We don't buy or என்னன்னு காமிக்க முடியாது. இந்த சர்வீஸ்ன்ற ஒரு கேட்டகரி we can't show, we can only avail and we can use. For example, in all our homes we have now internet. I am also speaking through that only. We all are using that Wi-Fi facility. We say it's a service. Phone illada yarume ipa illa. Telecommunication is a service. We can't show where is the connection, but we use it and show, right? Like that. And when it comes to service, the word what is the service is also defined, and it is defined in section 2 clause 42 of the Consumer Protection Act 2019. Already you would have come across many times. Service of any description which is made available to potential users. So it's made available, use panikrom. And it includes, this is not the conclusive definition, it's inclusive definition. It includes the provision of facilities in connection with banking, financing, insurance, transport, processing, supply of electrical or other energy, telecom, boarding or lodging or both, housing construction, entertainment, amusement, or the purveying of news or other information. As I told you, it's only inclusive but not limited to these services. ஏன் அப்படி வச்சிருக்காங்க அந்த டெஃபினிஷன்னா, services will come and go. இப்போ ஒரு 30 years before ஒரு டெலிஃபோன் கனெக்ஷன் அப்படின்றது எவ்வளோ பெரிய விஷயமா இருந்தது. Because telecommunication was not developed that much. அப்போ நீங்கள் மொபைல் ஃபோனுன்னு சொன்னால் கூட யாரும் யாரும் நம்பியிருக்க மாட்டாங்க அப்போ சொல்லியிருந்தா, ரைட்? பட் டுடே மொபைல் ஃபோன் இல்லாத யாருமே இல்லை. ஃபோனுன்னா அப்போ வந்து பெரிய அப்படி டயல்லாம் பண்ணி வீட்டுக்குள்ளேயே இருக்கும், ஏதோ ஒரு இடத்துல தான் இருக்கும், எல்லாருமே கனெக்டட். ஒரு ஃபோன் கனெக்ஷன் வாங்கணும்னா we have to wait for another 1 year and all like that. We have to book and wait and all, it was there. But now it's not so. Just go buy, give, put, connection, so easy it has become. So இன்னும் நிறைய சர்வீசஸ் இந்த மாதிரி வந்துக்கிட்டே இருக்கலாம். That is why they have not limited to any specific service. It's only inclusive definition. இப்போ நமக்கு தெரிஞ்ச எல்லா சர்வீஸும் இங்கே இருக்கு. And it does not include the rendering of any service free of charge. Again, buys தான். So விலை கொடுத்து அந்த சர்வீஸை யூஸ் பண்ணியிருந்திருக்கணும். Or under a contract of personal service. What is this contract of personal service means? Suppose I am hiring somebody. எனக்கு மட்டும் வேலை செய்ய நான் யாரையோ கூப்பிட்டுருக்கேன். அது என்ன வேலையா வேணா இருக்கலாம், சர்வீஸ், ஆர் he is doing a job, I am giving him money. So there it is between him and me, right? So there our terms and conditions will include that. So there whether he can file a case as a consumer, no. because that's a different case. Of course, he can ask compensation, civil court, etc. But whether he will fall under that definition of consumer is a big question, because it says it's a contract of personal service, right? And the simple, very, இந்த சர்வீஸ்ன்ற வார்த்தை வந்து ரொம்ப சிம்பிளா எப்படி நான் பார்க்குறேன்னா, குட்ஸ் இருக்கு, இந்த குட்ஸை வந்து மேனுஃபேக்சர் கிட்ட இருந்து கன்சியூமருக்கு கொண்டு போய் சேர்க்கறதுக்கு நிறைய விஷயங்கள் தேவைப்படுது, ரைட்? நான் மேனுஃபேக்சரிங் சப்போஸ் கன்னியாகுமரியில் பண்ணுறேன், சென்னையில் இருக்கிற ஒரு கன்சியூமர் அதை வாங்கிக்கிறாங்கன்னு வச்சுப்போம். நிறைய அப்படிதான் நடக்குது, எங்கேயோ மேனுஃபேக்சர் ஆகுது, இங்கே வருது. பட் இதை கொண்டு வந்து சேர்க்கறதுக்கு அந்த ஃபர்ஸ்ட் மேனுஃபேக்சரர் கிட்ட இருந்து லாஸ்ட் கன்சியூமருக்கு இந்த பொருள் போய் சேர்றதுக்கு யாரெல்லாம் வேணும்னு யோசிச்சு பார்த்தீங்கன்னா, இந்த சர்வீசஸ் எல்லாம் உள்ள வந்துடும். டிரான்ஸ்போர்ட்டேஷன் வேணுமா, ஸ்டோர் பண்ணிக்கணுமா, அப்போ டிரான்ஸ்போர்ட்டேஷன் வேணும்னா சப்போஸ் நடுவில் ஏதாவது ஆச்சுன்னா இன்சூரன்ஸ் வேணுமா? ஸோ ஏதோ ஒன்று நடந்திருக்கு, அந்த பொருளுக்கு குட்ஸ் அனுப்பி வைக்கிறாங்க, ஏதோ ஒன்று நடந்ததுன்னா இன்சூரன்ஸ் கம்பெனி வில் ஒர்க் அவுட். அண்ட் தென் வி நீட் money transactions, so automatically we need banking. Any information to be passed on, we need telecom. So if anything happens to people, then we need medical services. So and the goods manufacturer கிட்ட இருந்து கடைசி கன்சியூமருக்கு கொண்டு போய் சேர்க்கறதுக்கு சுத்தி இருக்கிற எல்லாம் தான் சர்வீஸ், simply speaking. Without going into any definition in the act, this is service. But yes, we have already definition under 2 clause 42 of the Consumer Protection Act 2019. And when it comes to services, the word used is deficiency of services. குறைபாடுள்ள, லைக் இதெல்லாம் தரேன்னு சொன்னோம் ஆனால் இது இல்லை அப்படி. இப்போ சிம்பிள், இன் அவர் ஹோம் வில் சே 2 GB 3 GB இன்டர்நெட், இந்த ஃபர்ஸ்ட்ல வரும் அந்த ஃபர்ஸ்ட்ல வரும். தட் இஸ் த ப்ராமிஸ் விச் எவ்ரி இன்டர்நெட் கம்பெனி கிவ்ஸ் அஸ். But whether it is coming in that speed is a big question. First of all, it's too technical. We don't even know அந்த ஸ்பீடில் வந்துதானே தெரியாது. ஆனால் அந்த ஸ்பீடில் உங்களுக்கு இன்டர்நெட் வரும்னு சொல்லி தான் அந்த எக்ஸ்ட்ரா காஸ்ட் and all is being got from us. Correct? So it's too technical sometimes services. And deficiency in service means any fault, imperfection, shortcoming, or inadequacy in the quality, nature, and manner of performance which is required to be maintained by or under any law for the time being in force, or as undertaken to be performed by the person in pursuance of a contract or otherwise in relation to any service, and it includes any act of negligence or omission or commission by such person which causes loss or injury to the consumer, and deliberate withholding of relevant information by such person to the consumer. This is section 2 clause 11 of the Consumer Protection Act 2019. Deficiency. So it's fault, imperfection. Mostly deficiency of services is imperfection only, because it's not working as what they agreed. Simple insurance company cases, if you look into, there are too many promises made in the while we take an insurance policy. But as consumers, we also have a problem. I'm talking about me or anybody as a consumer. Suppose we are taking an insurance policy. நம்ம எல்லாருமே எப்படி எடுக்கிறோம்? ஏதோ ஒரு ஏஜென்ட் வருவாங்க, அவர் ஏதோ கொஞ்சம் எக்ஸ்பிளைன் பண்ணுவார், இதெல்லாம் இருக்கு ஓகே ஃபைன், அண்ட் he will give us a paper. ஒரு இன்டூ மார்க் அங்கங்கே போட்டிருக்கோம், இந்த இடத்துல எல்லாம் கையெழுத்து போட்டுருங்க, இன்சூரன்ஸ் பாலிசி ரெடி. ஓகே, பட் அந்த இன்சூரன்ஸ் பாலிசி பேப்பரை, அந்த அவங்க கொடுக்குற அந்த டாக்குமெண்ட்டை ஆஸ் கன்சியூமர், அது நம்மளா இருந்தாலும் ஃபுல்லாக படிச்சிருக்கோமானா we don't know. Even it's not about illiterate people or somebody like that. Anybody, many educated people also, none of us we read that insurance policy fully. இந்த இடத்துல நான் ஒன்று ஒரு சின்ன I would like to go into another topic ன்னு கூட அதை சொல்லலாம். Today we are living in an era of standard form contracts, right? What is the standard form contracts means? Everything, this buying, selling, கன்சியூமர்லாம் வர்றதுக்கு முன்னாடியே இந்தியன் கான்ட்ராக்ட் ஆக்ட் இருக்கு 1872, or சேல் ஆஃப் குட்ஸ் ஆக்ட் இருக்கு 1930. இது எல்லாமே கன்சியூமர் தான். இட்ஸ் டாக்கிங் அபவுட் பையர் அண்ட் த செல்லர் ஒன்லி. பட் டுடே என்னாச்சுன்னா, ஆஃபர், அக்செப்டன்ஸ், கன்சிடரேஷன் இதெல்லாம் ஒன்றும் இல்லை, யாருக்கும் உட்காந்து பேசலாம் டைம் இல்லை. ஆல் த கான்ட்ராக்ட்ஸ் விச் we are entering into is fixed by one of the party. இப்போ இன்சூரன்ஸ் கம்பெனி எடுத்துக்கோங்க. எனக்கு இன்சூரன்ஸ் எடுக்கணும்னா நான் உட்கார்ந்து அவங்க கிட்ட கன்வே பண்ணி நெகோஷியேட் பண்ணி இதெல்லாம் நான் கொடுப்பேன், இதெல்லாம் நீங்க கொடுப்பீங்களான்லாம் இப்ப பேச மாட்டோம் யாரும். அவங்க ஆல்ரெடி ஃபிக்ஸ் பண்ணி வச்சிருக்காங்க. Terms and conditions of the contract is already fixed. You just go sign the contract, it's over. Only one choice is available for us. As a consumer, if you want you take, otherwise you don't take. Fine. எடுக்காம இருக்கலாம், fine. But நம்ம இப்போ ஒரு what the world which we are living is, it's compelling us to do many things. இன்சூரன்ஸ் இல்லாம யாரும் இருக்கக்கூடாது, மெடிக்கல் இன்சூரன்ஸ் இல்லாம யாருமே இருக்கக்கூடாது. லைக் everything is forced on us, like vehicle insurance or whatever. Insurance ஒரு எக்ஸாம்பிள் தான். I am not against any insurance company or anything like that, but all the insurance policies, anything you take, it's all fixed. So in the fixed already சொல்லும்போது there is something called disclaimer. எல்லா இன்சூரன்ஸ் பாலிசியோ இல்லை எனி ஸ்டாண்டர்ட் ஃபார்ம் கான்ட்ராக்ட் யூ டேக், there is something called disclaimer clauses. அதுக்கு நம்ம இன்னொரு பேர் என்ன சொல்லுவோம்னா exclusion clauses. These disclaimer clauses are actually excluding the liability of one of the party to the contract. அல்லது ரிஸ்க் ஃபேக்டர். நம்ம ரொம்ப ரொம்ப ஃபேமஸான மியூச்சுவல் ஃபண்ட் அட்வர்டைஸ்மெண்ட் நம்ம எல்லாருமே பார்த்துருப்போம்னு நினைக்கிறேன். டெய்லி வரும், இப்போவும் வந்துட்டு இருக்கு. அதோட கடைசியில ஒரு லைன் சொல்லுவாங்க, இல்லை, மியூச்சுவல் ஃபண்ட்ஸ் ஆர் சப்ஜெக்ட் டு மார்க்கெட் ரிஸ்க், ப்ளீஸ் ரீட் த ஆஃபர் டாக்குமெண்ட்ஸ் கேர்ஃபுல்லி பிஃபோர் இன்வெஸ்டிங். இந்த ஸ்பீட்ல இல்லை, நல்ல டபுள் ட்ரிபிள் ஸ்பீடு வச்சு இதை படிச்சீங்கன்னா அப்படி ஃபாஸ்டா சொல்லுவாங்க. அண்ட் சப்போஸ் மியூச்சுவல் ஃபண்ட்ல இன்வெஸ்ட் பண்ற ஒருத்தர் அவர் இன்னும் கொஞ்சம் உஷாராயி அந்த டாக்குமெண்ட்லாம் எடுத்து படிக்கிறாருன்னே வச்சுப்போம், படிச்சாலும் புரியாது. பிகாஸ் இட்ஸ் ஆல்ரெடி ட்ரெயின்ட், ஃபிக்ஸ்ட், எவ்ரிதிங் இஸ் ஃபிக்ஸ்ட். இட் வில் பி ரிட்டன் இன் ஸ்மால் லெட்டர்ஸ், ரிஸ்க் ஃபேக்டர்ஸ், அவ்வளோதான். இன்ஃபேக்ட் அட்வர்டைஸ்மெண்ட்ஸ்லாம் வில் டாக் லேட்டர், because tomorrow's class I thought of discussing all that. Product liability la பேசலாம்னு நினைச்சேன். But this disclaimer clauses in all standard form contracts are in fact excluding the liability. நாங்க இவ்வளவுதான் ரெஸ்பான்சிபிள் அப்படின்னு அவங்க ஆல்ரெடி சொல்லிட்டு தான் நம்ம கையெழுத்து போட்டதுக்கு அப்புறம் தான் it is coming into force. So the poor consumers, when they go and claim something, then only they understood, oh, இதெல்லாம் இருந்ததா, இந்த கண்டிஷன் இருந்ததுன்னு எனக்கு தெரியாது. So it's about awareness. It is about how we are being not allowed to negotiate. So in this era of non-negotiation, negotiation கம்மியாகிட்டே வருது. ஒரு சைடுக்கு பேசுறதுக்கு உரிமையே கிடையாது. நம்ம போறோம், அங்க ஃபிக்ஸ் பண்ணி இருக்கிறத வாங்குறோம், வந்துட்டே இருக்கும். We are also like that only. இப்போ நம்ம ஒரு பிராண்டட் ஷோரூம் லைக் பேட்டா ஷோரூமுக்கு போனால் எவ்ரிதிங் எல்லாமே வந்து 500.99 எல்லாமே 99 அப்படின்னு ஃபிக்ஸ் பண்ணி அங்கே இருக்கும். இட்ஸ் ஆல் ஃபிக்ஸ்ட், அவ்வளோதான். அங்கே போனால் 5,000 ருபீஸ்க்கு கூட கேள்வியே கேட்காம கொடுத்துட்டு வர நம்ம தெருவில் உட்காந்து பூ வித்துட்டு இருக்கவங்க கிட்ட ஒரு முழம் பூக்கு சண்டை போட்டு வாங்காமல் வரவே மாட்டோம். அவங்க 15 ரூபான்னு சொன்னால் நூறு 10 ரூபா தான் தருவேன்னு சொல்லி சண்டை போடலைன்னா நம்ம வரமாட்டோம். பிகாஸ் here we have that right of negotiation or something like that, but in branded showrooms we do not have that. அவங்க எவ்வளோ சொன்னாலும் fine, yes, வந்துட்டே இருக்கும். So it's all fixed already. Many of the services sector, it's fixed. The disclaimer clauses is becoming more and more very far, and என்ன அதுல இருக்குன்னே நமக்கு தெரியல. So that's the major, again, the next challenge which any consumer forum will face in the upcoming years is that whether this disclaimer clauses are reaching the consumer is a big question. But my point of view is you inform the consumer about that also. If he wants, let him take. அதுக்கப்புறம் அது அவர் எடுத்த ரிஸ்க், ரைட்? எல்லாமே படிச்சிட்டோம், எல்லாமே எக்ஸ்பிளைன் பண்ணியாச்சு, அதுக்கப்புறம் நீங்க எடுத்துக்கிறீங்களா அது உங்க இஷ்டம், அது உங்க ரிஸ்க். பட் இது எதுவுமே தெரியாம தான் எல்லா கன்சியூமர்ஸும் நம்ம many of the consumers are going forward with many of the service sector, and that's where we land up in deficiency in services. When we land up in deficiency in service, or when we want to file a case under that, we have to explain. Yes, இவர் டெஃபிஷியன்சி கமிட் பண்ணியிருக்காருன்னு நம்ம ப்ரூவ் பண்ணுறதுக்குள்ள இட் பிகம்ஸ் a failure, or many times the consumer doesn't win the case. Complaint. The next important point. We saw the consumer. Consumer is divided into goods and services, defective goods, deficiency and services. Now coming to the another part of very important part is complaint. How to file a complaint before the consumer forum. What is a complaint is also defined. It's any allegation made in writing by the complainant for obtaining any of the reliefs as stated in the act. So as usual, it should be in writing. So no oral. யாராவது வந்து orally explain பண்ணாலாம் அது வராது. The reliefs that can be claimed or for which the complaint may be filed are as follows. One is unfair contract, unfair trade practice or restrictive trade practice adopted by any trader or service provider, both goods and services தான். Defective goods, deficiency in services, goods sold or service provided in excess price as fixed by law enforced or displayed in the goods or in the price list or as agreed by the parties. This also very many times it happens. ஏன்னா ஒரு குட்ஸுக்கு, அதாவது ஒரே பொருளுக்கு ஒவ்வொரு இடத்துல ஒரு விலை. If you go take the water itself, water bottle, railway stationல ஒரு விலை, ஏர்போர்ட்ல ஒரு விலை, malls-ல ஒரு விலை, normal places-ல இன்னொரு விலை, like that. So it's, and the price which is fixed by law, I mean, or enforced or displayed, அதுலயே price 15 rupees in போட்டு 20 rupees விக்கிற இடம்லாம் இருக்கு. Like people who do not read, that also happens. And complaint can be filed for goods sold or services provided which are hazardous to life and safety and unsafe to the public. So that's general definition. Every day you are seeing such complaints. So I think you are the better person to know that. And who can be a complainant? Section 2, Clause 5 of the Consumer Protection Act 2019 says who can be a complainant. Already we did that, or already we discussed that in a short way. But a complainant means a consumer. So consumer யாருன்னு முதலே பார்த்துட்டோம். Or any voluntary consumer association registered under any law for the time being in force, or the central government or any state government, or the central authority, or one or more consumers where there are numerous consumers having the same interest. I think 1986ல இருந்து ஒரு சின்ன டிஃப்ரென்ஸ் இந்த இடத்துல வரும்னு நினைக்கிறேன், because class action and all is now started. So the numerous consumers can join together and file for the same interest. In case of death of a consumer, his legal heir or legal representative also can continue. Or in case of a consumer being a minor, his parent or legal guardian also can file a consumer. 2 Clause 5. So who can file a complaint before the consumer forum? These people. Generally, it's own. நான் தான் consumer, நான் file பண்ணலாம். Or voluntary organization, government, like that it will go. If it's minor, then yes, parent or legal guardian. Then complainant we have seen. So this is the gist of it. That is single consumer, recognized consumer association, class action for the benefit of numerous consumers, and central government or state government. And then consumer rights. When we talk about, consumer rights, when we talk about that, the generally what are the rights available? I think we all know once again, but first thing, consumer rights includes the right to be protected against marketing of goods, products or services which are hazardous. So marketing of goods, that's again the big challenge today we are facing, because today we can't avoid what we call as advertisement. அதை அவாய்ட் பண்ணிட்டு ஒரு இடமே நமக்கு இல்லை. ஸோ the companies are trying to market the products to us in any way or the other. It can be printed media, it can be oral, it can be any way. Somehow we will come across some goods. அது பார்க்காமலாம் இருக்கவே முடியாது. So in that case, we have a right to be protected against marketing of goods, products or services which are hazardous to life and property. The right to be informed. Now, I mean, and the GM products, I have the right to know as a consumer about the quality, quantity, potency, purity, standard, and price of goods so as to protect the consumer against unfair trade practices. The right to be assured, whether wherever possible, access to a variety of goods, right to choice. Of course, சாய்ஸ் சொல்லப்போனால் இப்போ வெரைட்டி ஆஃப் சாய்ஸஸ் வி ஹாவ் ஆல்ரெடி ரொம்ப நிறைய அதுதான் சொல்லணும் பிகாஸ் எகெயின் த சேலஞ்சஸ் we are we as Indian consumers are facing goods not only from Indian companies, we are also facing goods from our multinational corporations. So there's too many choices, but whether I am aware of all the choices is also again a question, and whether this choices is available to all the consumers is also a big thing. And third is right to be assured wherever possible access to a variety of goods, products or services at competitive prices. No compulsion on prices. I mean, whether I have a right to bargain is in branded, I don't have a right to bargain. I don't have negotiation. So competitive prices is a big question. And there's another legislation which is called Competition Act 2002. Again, it's a very, very important legislation where it goes parallel with consumer protection. But it is the difference between that legislation and this is that consumer protection is concentrating only on consumer. Competition Act is concentrating on others also in the market. But when it comes to competitive prices, to maintain competition in the market, we need Competition Act 2002. Then the very important right of a consumer is the right to be heard and to be assured that the consumer's interest will receive due consideration at appropriate forum. That's very important. Appropriate forum. Easily I should get a remedy. It should not be delayed for me. Because வெரி நான் ஆரம்பத்தில் சொன்ன அந்த டொனாக் வர்சஸ் ஸ்டீவன்சன் கேஸ் எடுத்தா கூட அவங்க ஏன் போறாங்க அந்த கேஸ்க்கு, நம்ம ஏன் இப்பவும் போகல, சாதாரண ஒரு விஷயத்துக்கு நம்ம ஏன் போகலைன்னா we are scared of the time and the delay or the money or things involved in the case. If I go for a case, what will happen? That fear is still there. That must be modified. And the right to seek redressal against unfair trade practice or restrictive trade practices or unscrupulous exploitation of consumers, and the right to consumer awareness. என்னை பொறுத்த வரைக்கும் the last one is a very, very important right, because right to consumer awareness is very much lacking even in this era. அதாவது ஒரு அன்ஃபேர் ட்ரேட் ப்ராக்டிஸ் ஒரு கன்சியூமருக்கு ரீச் ஆன அளவு கூட உங்களுக்கு உரிமை இருக்குன்னு ரீச் ஆகல. அவங்களால இந்த நுகர்வோரை ஈஸியாக ரீச் பண்ண முடியுது. அன்ஃபேர் ட்ரேட் ப்ராக்டிஸ், the most deceptive products, or I would say the advertisements which are coming in front of us, it reaches us very quickly. But we are not able to, I mean the legislators and the executive as well as the various forums are not able to reach the ordinary consumer and tell, see, I am here. If you have any problem, please come to me. You can get, that is very much lacking. That's the reason why implementation is bit, we are again going for the new legislation. Maybe if that is there, we will be more better, I feel. I think I am stopping here. Maybe we will take up some questions if possible, because too much of time I'm just continuously talking, I think so.
Ma'am.
Yes, ma'am.
Ma'am, உங்க நோட்ஸ் கொஞ்சம் ஷேர் பண்ணுங்க மேம்.
Yeah, sure. யார் பேசுறாங்கன்னு தெரிஞ்சுக்கலாம்
மேம்? தேனில இருந்து பேசுறோம் மேம்.
Yeah. நான் சரோஜா மேம்க்கு இந்த பிபிடி அனுப்பிடுறேன். மேபி யூ கேன் டேக் இட்.
Thank you மேம். நல்லா இருந்தது.
Thank you.
எனக்கு வந்து ஒரே ஒரு கன்சர்ன் தான் இருக்கு. Like we have 20 more minutes now.
Yeah,
And
okay. If you want, I'll go for one more because I have one more.
I'm just asking because tomorrow we have 1.5 hours. Will we be able to complete the entire to some extent?
Maybe I can continue, ma'am. No problem.
No, 10 minutes continue பண்ணிட்டு அதுக்கப்புறம் வேணா 5:20.
Yeah, sure. Yeah. 1 minute. I must share one more PPT for that. 1 minute. Yeah. 1 minute. Yeah. If you permit me, I'll share one more PPT because one of the salient feature is another. Was I able to share? No. Yeah. The apart from this definitional changes, the most I would say the important uh, salient feature which has come up now with respect to the forum. I just told you, effective administration is now the need. For that purpose, already there were forum, national, district, state, but apart from that, now we have brought in, or the legislation, new legislation has brought in Central Consumer Protection Authority, which is otherwise CCPA. So now the forum is looking like this. We have consumer protection, consumer disputes redressal commissions, from where you all have come, district, state, and national commission, which was already there. The change which has come in the 2019 Act is Central Consumer Protection Authority and Consumer Protection Councils. So now the forum, or the authority, the hierarchy, or I would say the administration of consumer affairs, or it goes like this. These are the forums which has come up now. The Central Consumer Protection Authority has been given a general mandate to regulate matters related to the violation of consumer rights, that is unfair trade practices, misleading advertisements under Section 18. It unambiguously clarifies that the CPA has the power to protect and promote and enforce rights of consumers as a class. As I told you, the class action suits and all. So as a group, you can go for it. Similarly, the CCPA has a power to refer matters for investigation or to another regulator under Section 19 of the Act. So they can take it up. The CCPA can order to recall the goods or withdrawal of services which can harm the innocent consumers under Section 20. So CCPA, that is Central Consumer Protection Authority, is now given that I would say the overall authority of all, and without even normally we used to go to district commission, state commissions, as an appeal we used to go. But today, as a central authority, directly a consumer can approach CCPA. So that's one of the very important salient feature which I find in the new legislation. In that regard, the other thing is the rights which we already read. And another, as I told you, the salient feature is under 1986 Act, there was no clear definition for what you mean by misleading advertisement. Because as we continue from the previous, where I stopped earlier, this misleading advertisements is now considered as a menace. Advertisements is not a menace. Misleading advertisements is a menace. Because advertisements, generally before going to the what do you call, the act or anything, advertisements are needed, because when a manufacturer or when a product is coming into the market, advertisement is the medium by which it reaches the consumer. So as a new consumer, I am getting to know about many products. That's the role of advertisement. That's correct. But Section 2, Clause 28 defines misleading advertisement as which is falsely describing the product, gives false guarantee to mislead the consumers as to the nature, substance, quantity, quality, anything it can be, to mislead. That is, the consumer is told more information or exaggerated information about the product, right? Or he is told less information. Both are misleading. If you tell exaggerated information or if you tell lesser information, both are considered to be misleading only, provided it is with respect to the nature, substance, quantity, or quality. Starting from any, when I talk about misleading advertisements, every time that comes to my mind is what is that? What is that? I would say any cosmetic advertisement or something like that, because it always promises something called fairness. Like, I don't want to tell any company's name here, but all these fairness or cosmetics or anything that comes as an advertisement promises that if you use it, you will become somebody, right? And the most disheartening thing is that apart from the product, there is a wrong impression brought in front of the public or even women, or I would say something. Advertisements show women in a very, very, very indignified way, I would tell. Because starting from small children to the higher, they show that, for example, a masala or something like that, one of the advertisements says that if you use that, the student will get good marks. And cosmetics, when it comes, only people who are fair will get a job, only people who are fair will get married, or only people who use that fairness cream or something will be in the higher status. That itself is, the social values are wrongly shown. In that way also it is misleading. This is my humble opinion. But as far as Act is concerned, it very clearly tells that misleading advertisements conveys explicit or implied representation of unfair trade practice. So this misleading advertisements then only goes to unfair trade practice. It leads there. And it deliberately conceals some important information. As I told you, most of the standard form contracts, in the disclaimer clauses, they hide everything. Indirectly, they say, which does not, is not. So misleading advertisement is also included within this as a separate definition, wherein in product liability, this takes a long way. And when it comes to the unfair trade practice, it's I see it as a continuation. 2 clause 47 defines unfair trade practice. Here it says adopting any unfair or deceptive method for the purpose of promoting the sale, use or supply of goods or for the provision of any service. One thing we have to remember, wherever they say goods, yes, it is again, it applies to both, what do you call, services also. And making any statement through verbal, written, visible representation, including electronic mode, which falsely represents the goods or services are of particular standard, falsely represent old goods as new goods, falsely represents something which is having sponsorship or characteristics, or falsely represents that the seller or the supplier has approval or application. All these are considered to be unfair trade practice only. And making misleading or false representation regarding the need for the usefulness of the goods, gives warranty or guarantee about the product, which is not based on adequate proof. For example, in many advertisements, they show a survey taken with the children. For example, the drinks and all, like if you drink, you will become taller, shorter, etc., etc. Such type of drinks and all. They show a survey saying that we took survey with 100 people or 100 children. But if you clearly watch the advertisement, you will know that the survey would not have any authenticated proof, whether it is taken, where it is taken. And in most of the things, it would be taken in some abroad. So my question is, like, regarding health and all, the health of children in India and health of children in America need not be the same. So a survey taken in America, how far it will be applicable in India itself is a big question. So that itself is unfair trade practice. And misleading the public regarding the price. In gold and all, we can see this. The advertisement will say that it is this much percentage cut off, there is no that, this and all. But when we really go, it would look like they get this price in some other way. So that's unfair trade practice. That's one of the very important feature which has been introduced in this 2019 Act. And it continues, it's a big section. False or misleading facts regarding comparing the goods. Like one company will tell, we are the best. So automatically they are telling the other company which is selling the same product is not good. And permitting the publication for a bargaining of price of goods or services that are not intended to be offered. As I told, all these offers, when it comes, in fact, they give offer in one way, they take away the offer by the other way. In any other thing, they will increase the price. And not issuing bill or cash memo. This is a very common affair, which even educated people, many times we don't get the bill. Actually, if bill or cash memo is not provided, that is also considered as unfair trade practice under the Act. and refusing to take back the defective goods after selling them. This again in online transactions, it becomes a very, very important challenge because in many of the online transactions, the goods, when it comes or reaches the consumer only, the consumer is able to view the product. So maybe he got a wrong product or a defective product, then there must be opportunity to take back. So that's, if they do not, then that is also unfair. Manufacturing or offering of spurious goods, disclosing the personal information of consumers unlawfully to another person. This, I would say, again, the biggest challenge which is going to be faced by the consumer forum in future, because today most of the online transactions, they ask for some informations where to click and come back and pay and all, you need to give information. So this information, whether it is used properly, you know, there was a judgment by the Supreme Court of India where right to privacy is a fundamental right. So in that case, suppose I am giving my information to purchase of one product. If that information goes away to another person, that itself is violation of my privacy only. So disclosing the personal information of consumers unlawfully to another person is actually unfair trade practice under the Consumer Protection Act. That's why I said it has been expanded. The feature itself is, it has been expanded. But unfortunately, we are yet to see that how it will be coming, especially with respect to this confidentiality of information. Because we would have experienced, if you go to a shop and purchase something, they'll ask for a phone number. In case you give the phone number, from next even next year or next month or anything, messages will come from that shop. But if you clearly observe it, you will find that not only from that shop, many other places also advertisements are coming. So for example, you get advertisement calls in your phone, you get advertisement messages in your phone. How did they get my number? So somewhere somebody has disclosed my number to somebody, correct? So right to privacy or disclosing of personal information would be one of the biggest challenges, because data is now being sold. That's what to say. And section 10 clause 2 of members of the central authority, they are appointed by central government. And of course, chief commissioner, other commissioners are there. And 10 clause 3 headquarters is there, that is there. And regarding CCPA, once again, these are the powers of the CCPA. They can investigate and inquire either suo motu or on a complaint received on the directions from the central government, filing complaints before district commission or state commission or national commission, intervene in any proceeding before the commission, review the matter and recommend appropriate remedial measures, recommend adoption of international covenants and best international practices, undertake and promote research in the field of consumer rights. So CCPA is now one overall authority where given powers, 18 clause 2 gives their powers, and they also have a duty to spread and promote awareness on consumer rights. And that's where we are all sitting here, like not only training, but it is also again spreading the awareness of consumer rights is very important so that it reaches every consumer. And they have a right also to, duty to issue guidelines to prevent unfair trade practices and mandate the use of unique and universal goods identifiers to prevent unfair trade practice. So it's a good number of powers is being given to the CCPA, Central Consumer Protection Authority. And section 20 says that authority can, on the basis of investigation, may pass orders. What are the orders the CCPA can pass is, they can recall the goods or withdrawal of services, reimbursement price to purchasers, discontinuation of unfair and prejudicial practices. And 21, if they are on the basis of investigation, if they are satisfied that regarding advertisement, they have a right to issue directions to discontinue or modify the advertisement, either to the manufacturer or to the endorser. Penalty for misleading advertisement up to 10 lakh rupees. When I use the term endorser, it refers to the person who appears in the advertisement. again, this is again a salient feature of this act, because in 1986 Act, we did not have a proper definition for misleading advertisement, and also we did not have the definition or something, the liability for an endorser. Endorser means anybody who comes and appears in an advertisement. And here we have to concentrate on one point called celebrity endorsement, right? So today celebrities are also liable for the product which they are endorsing. It's why and all product liability, we will talk there. And endorser also can be prohibited for a period of up to 1 year, and for subsequent contravention up to 3 years. And to any person is found to publish or party to publish misleading advertisement, then the penalty can be up to 10 lakh rupees. So it's good number, and misleading advertisements is getting a very, very properly regulated, I would say. Because in India, even though we have so many legislations, if you ask what is the legislation that is governing advertisements, we can't answer in one line, because it's all scattered. There is no one single legislation, comprehensive legislation to regulate advertisements. Now, Consumer Protection Act is taking that, 2019 Act is taking a huge step in that regard. And this penalty, how they are actually deciding, like 21 clause 7 says how this has affected the advertisement, how it has been impacted, that is population and area affected by such offense, frequency and duration of the offense, vulnerability of the class of persons likely to be adversely affected by such offense, gross revenue from the sales earned by such offense. So as officers, I think you should know, like when you are imposing penalty, how far it was affected, how much they were affected, and what is the revenue which they made because of this affected, right? And section 24 says person aggrieved by any order passed by the central authority under section 20 and 21 may file an appeal to National Commission. The time limitation to file an appeal to National Commission is 30 days from the date of receipt of order. So regarding advertisements, yes, many new things have come. I hope we can stop here.
Yeah, thank you so much. That was quite.
Yes.
Yeah.
Yes, ma'am.
Yeah, now the floor is open for questions. So if there are any questions, please raise your hand.
I think there were some questions in the chat box. Let me check it out.
Yeah, please.
Because who can file a complaint in case of died consumer? All his legal rights or anyone of legal rights? And I think legal rights, I think legal heirs can file a case. But when it comes for compensation and all, like suppose say only one person is filing and he got compensation, and how it will be divided, all this comes in. I feel that legal heirs have to combine and file a complaint. Like consumer complaint can be proceeded if he happens to be a legal heir. One legal heir also can file. It need not everybody should come in, I think.
Ma'am, we have one question.
Yes, sir.
Actually, whether the district commission can refer the matter to the CCPA for investigation.
I think yes, sir, because now the hierarchy is they can take up suo moto also, no? So instead of going as an appeal from here, they can even take suo
order
moto.
Investigation by a CCPA. Whether a district commission can order investigation by a CCPA.
Yes, sir. Like CCPA is the higher authority. So normally when cases are filed there directly to Delhi, if you go, then they will only order this side, no? They ask us to investigate and send a report there. So when it is filed before the district commission, can we go to a higher authority for investigation?
It's not a question of higher authority. Here, the case involves, assuming that it is a case of unfair trade practice.
Okay.
It applies to entire pan India.
Correct.
Okay. The commission feels that it has to be investigated by a central authority.
That's
so whether in that case, whether we can refer the complaint to the CCPA for investigation.
practically, we need to we are yet to find out that, sir, because in the act there is no clarity regarding that. Because CCPA has a powers, all these things we can do. But when a complaint comes before the district commission and the district commission feels that it is to be investigated by a higher authority, then I think
But actually,
practically
there
we
is a
need.
provision under this new act, section 70.
Yes, sir.
It says complaints to authorities.
Okay.
A complaint relating to violation of consumer rights or unfair trade practice or a false misleading advertisements which are prejudicial to the interests of the consumers may be forwarded either in writing with the electronic mode to any of the authorities, namely the district collector, the commissioner of a regional office, or the central authority.
Okay.
Here, they plead only by the way of complainant.
Complaint.
Yes, by way of a consumer.
Yes, yes.
Consumer can directly approach the authorities.
Yes, yes, they can.
Yes. Why not the consumer forum cannot order
Forum
that?
apply. Yes,
That's only
but
good
that's a very relevant question, sir. But I think there is one point upon needs clarity in the act itself, because act speaks about only complaints to authorities. As I told you, they can even take up suo moto the complaint directly. We can go to CCPA, but whether the commissions can go to CCPA is not clarified.
No, not actually. We are ordering the CCPA to go for
to investigate whether that's possible. Is practically we need to,
because we have powers.
Yes.
To pass order.
Yes.
To stop the unfair trade practice.
Yes, yes.
So is it not our duty to order the CCPA
True.
to conduct an investigation to stop unfair practice if it is prevailing in other places?
Other places also, correct.
Yes.
But definitely it can be referred, I think, sir, because as I told you today, it's a fast moving world, and whatever is available in one part of the state is available in another part of the country also.
Yes.
Easily it is getting so it's as you tell, slowly one by one all consumers getting affected. It is better when you see here we can report there, and yeah, that's a very good
particularly in the misleading advertisements.
Misleading advertisements, true, sir, very true. Yes, because the media is taking it up everywhere, you can see that. Yes, true, sir. When it is a national wide issue, yeah, when it is a nationwide issue, they themselves can investigate. And true, sir, that's very good suggestion. Probably we need to write somewhere to amend and make a clarity in the act itself. I don't find provision in the act, I think. Yes.
Okay, sir.
Yes, sir.
Madam, one question.
Yes, sir.
Whether the Evidence Act is applicable for consumer protection product?
Yes, sir. Yes, sir. I didn't hear you. What, sir?
Whether the Evidence Act is applicable in the district commissions with regard to summary trial?
Sir, usual proceedings as a civil court or not the exact proceedings, no, but
Madam, one doubt.
Yes, sir.
Madam, as per the section about the ex parte set aside, section 61.
61. Okay, sir.
What is the clarity, madam?
61. Yes, sir.
Whether it is applicable only for National Commission or it is applicable for District Commission or State Commission?
When an order is passed by the National Commission ex parte, the aggrieved party may make an application to the Commission for setting aside such order. I think it applies to...
My question is...
Yes, sir. I think it applies to National Commission, sir.
Yes,
we are talking about National Commission.
Where an order is passed by the District Commission as ex parte, what is the position?
Okay.
ஒரு டிஸ்ட்ரிக்ட் கமிஷன் ஒரு எக்ஸ் பார்ட்டி ஆர்டர் பாஸ் பண்ணிட்டாங்க கரெக்ட் செட் பண்றதுக்கு என்ன பண்றது
அங்க திரும்ப அங்கேயே தானே சார் என்ன யூசுவல் எக்ஸ் பார்ட்டி ஆர்டர்ஸ் நம்ம செட் அசைட் பண்றதுக்கு அதே கமிஷன் கிட்ட தானே சார் போறோம்
அங்கதான் இல்லையே அப்படித்தான் இல்லையே அதுக்கு தான் உங்களை கேக்குறேன் நான்
ஓகே
I read your president I am asking a question that
நேஷனல் கமிஷனுக்கு மட்டும் அந்த பவர் கொடுத்திருக்காங்க ஆக்ட்ல
இந்த ஆக்ட்ல நேஷனல் கமிஷன்ல எக்ஸ் பார்ட்டி ஆர்டர் பாஸ் பண்ணா அவங்க செட் அசைட் பண்ணணும்னு சொல்லியிருக்காங்க.
ஆமா.
டிஸ்ட்ரிக்ட் கமிஷன் எக்ஸ் பார்ட்டி ஆர்டர் பாஸ் பண்ணா செட் அசைட் பெட்டிஷன் பண்றதுக்கு என்ன பண்றதுங்கிறது என்னோட கேள்வி.
Proceedings before the district commission வரிசையா பார்த்துக்கிட்டே இருப்பாங்க. எங்கேயுமே டிஸ்ட்ரிக்ட் கமிஷனுக்கு எக்ஸ் பார்ட்டி பண்றதுக்கு தான் பவர் கொடுத்துருக்காங்களே தவிர.
Sir, I agree with you, sir. Agree with you, sir. I am asking our resource person.
Sir, section 38ல நீங்க அந்த section clause 3 subclause la ex parte on the basis of evidence brought to its notice by the complainant where the opposite party omits or fails to take any action to represent his case within the time given by the commission இருக்கு இல்லையா sir?
So அப்ப வந்து டிஸ்ட்ரிக்ட் கமிஷனுக்கு எக்ஸ் பார்ட்டி செட் அசைட் பண்றதுக்கு பவர் இருக்குன்னு நீங்க சொல்றீங்க, கரெக்ட் தானே?
I mean அந்த section 58ல பாருங்க sir. 38 I'm sorry 38.
மேடம் அதெல்லாம் இல்ல. டிஸ்ட்ரிக்ட் கமிஷனுக்கு பவர் இருக்கா இல்லையா? நீங்க உங்களுடைய வெர்ஷன் என்ன?
அது படிச்சா இருக்குன்ற மாதிரி இருக்கு சார்.
இட்ஸ் ஓகே. ஆனா இல்ல, அதுதான் உண்மை.
Okay, practically I should read it sir. Yes sir. But adula district commission shall if the complainant admitted.
Being expert in the consumer law, I asked this question.
Sir, expert in அதுல இருக்கே expert in தானே சார் போட்டிருக்கு.
எக்ஸ் பார்ட்டி பண்றதுக்கு டிஸ்ட்ரிக்ட் கமிஷனுக்கு பவர் கிடையாது அப்படிங்கறதா இப்ப நேஷனல் கமிஷனோட சுப்ரீம் கோர்ட்டோட ஆர்டர் மாறி பண்றதுக்கு தான் உங்கள்கிட்ட கேட்டேன். நீங்க இருக்குன்னு சொல்றீங்க, பட் இல்லைங்கிறதா உண்மையான நிலைமை.
எக்ஸ் பார்ட்டி பண்றதுக்கு பவர் இருக்கு சார், செட் அசைட் பண்ணதா சார் பவர் இல்ல.
பவர் இல்ல.
செட் அசைட் பண்றதுக்கு பவர் கிடையாது. நீங்க வந்து பவர் இருக்குன்னு சொன்னீங்களா, அந்த ஒரு கிளாரிபிகேஷன் தான் கேள்வி.
சார் அவங்க சைலண்ட் ஃபியூச்சரை தான் சார் சொல்றாங்க. Ex parte set aside
no, I am not asking question from you. I am asking the expert who is giving.
I will just find out sir, or I should clarify because practically நீங்க தான் அத பாக்குறீங்க. That's true sir.
My question is the resource person who is giving lecture for us.
Sir, true sir.
We want to learn from them.
Practically you are the boss sir. நீங்க உங்ககிட்ட இருந்தா நாங்க கத்துக்கணும்.
அப்புறதுக்கு எங்களுக்கு ட்ரெய்னிங் நீங்க குடுக்குறதுக்கு தான ட்ரெய்னிங் கொடுத்து தான வந்திருக்கீங்க.
Sure sir. அது நீங்க I think இந்த क्वेश्चन கண்டக்ட் பண்றவங்க கிட்ட கேட்டா நல்லா இருக்கும்னு நினைக்கிறேன். ஏன் ட்ரெய்னிங்?
Same question we adapted. Ramraja sir question.
Yes sir.
Ramraja sir கேட்ட கேள்வியை நானும் கேக்குறேன் மேடம்.
Okay sir.
Yes sir.
So next question madam.
Yes sir.
Mediation center.
Yes sir. Mediation
center. அதுக்கு வந்து மீடியேட்டர்ஸ் வந்து அப்பாயின்ட்மென்ட் பண்றோம். எப்படி பணம் கொடுக்கிறது?
Practical question sir. You have to speak to the government.
தான எங்களுக்கு ட்ரெய்னிங் தேவை. நாங்களும் படிக்கிறோம்.
சார் ஆக்ட் வந்து பிராக்டிகலி அப்ளை பண்ண வேண்டியது நீங்க சார். அது பணம் வருதா வரலையா, அதுல இன்ஃப்ராஸ்ட்ரக்சர் இருக்கா இல்லையான்னு how can a trainer say sir?
After the section, if the district commission is making an appointment of mediator, how to pay the money to the mediator? This is the practical question. We need answer for this.
Sir, you can ask a question of Friday session, sir. Mediation. Friday session, 2:30 to 4 p.m. Mediation under the Consumer Protection Act.
It's okay, sir.
Actually, excuse me if I may actually step in. From my limited knowledge, it is left to the discretion of the commission to decide actually on what the mediator should be paid அப்படிங்கிறது. அதனால
who is only the advocates has to pay.
In my understanding, sorry to intervene, sir. In my understanding, yes, I think once they set up the mediation centers, the state government and the state commission should actually take a call. They should decide on how it should be fixed for the
paid. Yes, madam.
Yes, sir. So this is what I wanted to convey.
Because Act is giving only an outline of what is a mediation cell, how to appoint, etc. Sir, adoda appointment, adoda practicality, when the government should answer. Because once you appoint and start appointing, only the practicality will come.
Madam, that can be calculated from the resource person who is going to come on Friday.
A resource person also will be talking about what is.
Yes. From him you can get all the
of things. Sorry. So
the expert order also we can get clarification from the person who is going to come on 26th. Interpretation of the legal provisions under the Consumer Act. You can clarify.
Yes, sir. Please. I think that would be better. And also one ஒரே ஒரு சின்ன இது அந்த சார் கடலூர் டிசி டிஸ்ட்ரிக்ட் கமிஷன்ல இருந்து சார் வந்து அந்த கேன் பி ஆர்டர் த சிசிபிஏன்னு கேட்டிருந்தாங்க ஆன் இது டு இன்வெஸ்டிகேட் இன்டு அன்ஃபேர் ட்ரேட் பிராக்டிசஸ். திங்க் practically or even legally that may not be possible because these are two parallel entities, and this is an authority that actually, in addition to the commissions, this is another authority that has been put in place to actually protect the interests of consumers. So district commissions already have the power to actually take action on unfair trade practices. In addition to that, CCP, maybe the district commission can actually write to the authority and investigation, but in my understanding, I don't think the commission can direct the CCP.
No direct.
See, the practical difficulty in mind la enak immediate enak enna thonudhu appdin sonnaka, there is every possibility that all the commissions for some reason or the other might be directing the CCP and it could become an ineffective body ultimately. So I don't think that will be possible under the present setup. With whatever has been in mind when they actually came up with this authority. In addition,
we feel that it is a debatable question, ma'am.
Okay, so என்னோட response to this is this, but yes, definitely we can discuss, we can debate, we can see if that is practically possible. ஏன்னா இப்ப பாத்தீங்கன்னாக்க CCPA என்னோட question என் மைண்ட்ல என்னன்னாக்க, okay, you have the central authority. Like they are active. We have been seeing in the last several months, like they have been taking several actions, proactive. But then when it comes to the states, like it trickles down, and then we talk about the powers to the collector and all that. So other way, practical states, how effectively we are going to actually enforce.
There is an hierarchy of officers even under the CCPA, where they have a regional officers also.
Yeah.
But if the issue involves, it's a pan-India.
Yes, definitely.
The issue involves is a pan-India, whether regional officers have a control over it.
Regional officers will not have control. They will only have to recommend.
Actually, it has to be investigated by a CCPA.
But it is a parallel body. I don't think the commissions will be able to intervene there. But if they identify, they will file cases before the commissions. That is how it is presently.
In case if the commission, if any complaint is brought to the notice of a commission, district commission,
yes, sir,
and the district commission wants to bring it to the notice of the CCPA while passing an order, what prevents the district commission to pass such orders? That is the only question we want to know.
You say that you want the district commission to direct the CCPA to investigate into something.
Whether it can order the CCPA to go for investigation in a particular complaint.
No,
where it affects the consumers at large.
I get your point, sir. I think this is the present understanding of the setup, but we can always debate and discuss this. This is a topic in itself that we could actually discuss. Thank you very much, sir, for bringing this up. Thank you.
Tanaja?
Yeah.
Professor, madam.
திருவாரூர் கமிஷன்ல இருந்து non-advertisementக்காக ராக் சால்ட் வேற மிஸ்லீடிங் அட்வர்டைஸ்மெண்ட்டுக்காக ஒரு ஆர்டர்ஸ் போட்டோம். அதை சிசிபி டைரக்டா அனுப்பியிருக்கோம். அதை சால்ட் கார்பரேஷன், ஃபுட் சேஃப்டி டிபார்ட்மெண்ட்லாம் ரொம்ப அப்ரிஷியேட் பண்ணி அவங்க எல்லாம் எங்ககிட்ட காப்பி வாங்கியிருக்காங்க. பட் சிசிபில இருந்து ரெஸ்பான்ஸ் இல்லை எங்களுக்கு.
இல்ல
சொல்லணும்னு நினைச்சேன் சுரேஷ் சார், விஸ்வா சார், நீங்க கொஞ்சம் கண்டிப்பா பண்ணுங்க. உங்களுக்கு காப்பி அனுப்பி வைக்கிறேன் சார்.
Okay. So, இப்போ whatever I said, actually பாத்தீங்கன்னாக்க இப்போ வந்து ரெண்டு independent bodies, so இது ஒரு direction இருக்கு. So நீங்க பண்ணிருக்கிறது is a good thing because ஒரு particular caseல you have taken you have actually passed orders and you want it to be it's a pan India issue.
Yes.
It has something
வேற ப்ராடக்ட்ஸ் அதே மாதிரி இல்ல மிஸ்யூஸ் பண்ணிட்டு இருக்காங்க.
அதான் மேம், அந்த பர்சுவேசிவா இது இருக்கலாம். டிஸ்ட்ரிக்ட் கமிஷனோட ஆர்டர் அவங்களுக்கு ஒரு பர்சுவேசிவ் எஃபெக்டா இருக்கலாம். ஆனா நீங்க சொன்ன மாதிரி பிராக்டிகலி இவங்க அவங்கள ஆர்டர் பண்ண முடியுமான்னு டவுட் தான். சார் கேட்டது வந்து கேன் வி ஆர்டர் இன்வெஸ்டிகேஷன் பை தெம். அது பிராக்டிகலி ஆக்ட்ல இப்ப வரைக்கும் இல்ல, பாசிபிலிட்டி இல்லன்னு நினைக்கிறேன். பட் இங்க பாஸ் பண்ணப்படுற ஆர்டர் பர்சுவேசிவா இருக்கலாம். நம்ம காப்பி அனுப்பி இது pan India இஷ்யூன்னு சொல்ல முடியும்.
Yes, if the issue involves particularly with respect of unfair trade practice, misleading trade, what you call advertisement.
Yes. அந்த இடத்துல பர்சுவேசிவா கண்டிப்பா இருக்கலாம் இல்லையா? இந்த மாதிரி நடக்குது, இது அங்கேயும் விற்கப்படுது, so it needs to be taken care of. Yes, sir. That can be done.
Yeah, I think we need to have more conversations around this, sir. Actually, we need to bring in CCPA and the additional secretary who's the chief. அவங்களையும் கொண்டு வந்து I think we need to have this conversation. A very healthy conversation because in the interest of consumer தான் நம்ம பேசுறோம். So I think it's really good. We should actually plan for one discussion.
Regarding one suggestion, we can sumoto include the CCPA as one of the party to the proceedings, and we can direct the CCPA to investigate.
Yeah, அதுதான் இப்ப பேசிட்டு இருந்தோம். Actually, I don't know who's talking actually.
We can sumoto include CCPA as one of the party to proceedings. After that, we can direct the CCPA. Since அவங்க one of the party உள்ள இருக்காங்க இல்லைங்களா, அதனால அவங்கள வந்து நம்ம
இல்ல அவங்க எப்படி one of the party இருக்காங்க? Unless they file a case, how will they be a party to the case?
sumoto நான் இம்ப்ளீட் பண்ண முடியாது, இம்ப்ளீட் பண்ணிட்டாக்கா.
I don't think that is very far fetched in I don't think that will be possible. But sir, I think we let us discuss. Sorry, they were a topic, but still let me see if we can actually organize kind of a discussion. This could be see and okay, any other questions?
Professor Madam.
Yes, sir.
Tomorrow we will continue, Madam.
Yes, sir.
Yes, sir. Yes.
38 of
Thank you very much, sir. Ellarum, thanks, ladies and gentlemen, for being here today. I think it on the first day went well. Thank you, Dr. Harita, for and we'll look forward to hear you, listen to you tomorrow as well. So first session is going to be yours. So நாளைக்கு வந்து நம்ம திருப்பி 2:30 let us all meet. Thank you very much.
Thank you.
Thank you, madam.
Thank you, madam.
Thank you.
Thank you. Appreciate you. Nice presentation.
Elaborate சொல்லிட்டாங்க. In future physical training சஜஸ்ட் பண்ணுங்க.
கண்டிப்பா மேம், நான் ஃபர்ஸ்ட் ஆரம்பிக்கும் போதே சொன்ன மாதிரி இப்போ வந்து
நீங்க பார்க்கும்போது எனக்கு ரொம்ப ஹாப்பியா இருக்கு.
இல்ல ஏதோ ஃபீவர் அது இதெல்லாம் சொல்றனால so the commission was concerned, actually state commission was concerned. அதனால இப்ப ரிஸ்க் எடுக்க வேண்டாம் அப்படின்னு தான் சொன்னாங்க. Maybe next meeting, definitely next year we can plan for a physical meeting. Sure.
இது